Make sure we are indeed live. Perfect. Okay. All right. I, Kimo Gandil, the presiding officer, are going to call this meeting to order. At this time, I'm going to be going over some housekeeping before we move for the oral arguments on the motion to dismiss on grounds. For one, did both of the parties receive the email that I had sent earlier on the format? Mr. Frusiakis and Mr. Gates, can you please respond? Did both of you receive that?
Yes.
I'm sorry.
Mr. Gates?
I'm sorry, what was the question?
You received the format I had sent earlier?
Oh, yeah, I received it.
Perfect. All right. I am going to be following that pretty to the T. I will give you about, just so you know, my paradigm when it comes to enforcing time limits. As you saw with the preliminary, I was slightly lenient because we have a time restriction. I'm going to be slightly less lenient this time, especially because there's less procedural stuff. I'm going to give you probably like a 10-second leeway on time, but after that, I'm going to interrupt you. So please just kind of stick to the time limits. When it comes to portraying faces, witnesses that are on this chat, I would ask them not to speak until it's their turn to be asked questions or to respond. And I'd ask that they only show their faces while in response or being questioned, because otherwise this chat is going to lag because there's so many people on it. Do all parties understand these kind of basic rules?
Yeah, I was going to call my witnesses like individually, if that's fine, just so like there's no
that's
lag.
Yeah, because we're already going to be slightly lagging on this, so that would be highly preferable. All right. Are there any housekeeping or standing rule questions for me before we begin this whole process?
Go ahead, Dylan.
Oh, sorry. So the case comes before the dismissal argument? We're doing that first? So,
who's talking? I cannot hear you.
Me, Dylan.
Who's
Turn up
me?
your mic, Dylan.
Yeah, Dylan, we can't hear you. It sounds like you have a blanket over your mic.
Is it better?
No.
No.
Let me get my headphone mic. I'll be right back.
Dylan, do you have a pair of like Apple earphones?
That's what I'm going to go get.
Okay. I could hear that. We're going to give Dylan 30 seconds to grab that. Then we're going to just begin into this because we have a lot we need to do tonight.
How long do you expect this to take, Kimo?
The oral arguments or the entire trial?
The trial counting like all the arguments, like you know how you laid it out with all the minutes.
I hope we can adjourn around 10.
Okay.
All right, Dylan, we back? Oh, wait, no, Dylan's not back, clearly. All right, I'm just going to go through some formalities then so we can get these out of the way. The dismissal at hand has to do with grounds. The Judicial Board is going to be looking for arguments that are topical either to what occurred now and can be resolved as applicable to the relevant charge, and all of you should have the relevant charges in front of you. If you have questions on that, you can either ask a point of parliamentary clarification, not really a thing according to Roberts, but I'll permit it. Or there's a specific form of relief you are asking Judicial Board. So clearly, if the form of relief is not just a solvency regarding a chartering material, then that's outside the grounds argument for these oral arguments and should be made during the trial. This grounds argument seems to mostly be referencing charters, so let's keep it topical so we can save the majority of the substantive argumentation for the trial period, and I'm sure not bore our viewers with unnecessary technical jargon. So just make it relevant to if the charter at hand has grounds to be attacked. And if it does, if it even has standing, meaning an argument can be made, then I should strike down the motion in my final opinion. So clearly the burden is on those making the motion for proof.
Wait, Chemo,
Perfect.
could you clarify?
Looks like we've done.
Can you hear me?
Yes. So yes.
Wait, so
it is.
As I understood it, just reading like the form that you sent, I thought it was a 10-minute, like that's our speech for our argument, and then there's witnesses. What are you talking about here, where it's like two different speeches?
This is oral. So this is at the bottom, special rules for oral argument on the motion to dismiss. This is not on right now the outline of proceedings for the actual trial.
So
because
you
didn't want to respond.
Right?
We can do this before or after. It doesn't
prefer we
matter.
do it
I would,
if you wouldn't mind.
I'm fine. Or the oral argument's just going to be, I'll write about it first in the opinion, but we can move into the trial barring objections. Because I'm not going to address it right now, and Matt and I have already discussed this. We'll address it in the opinion.
I'm okay with whatever order as long as we get to address it at some point.
Excellent. Pursuant to page 15 of Robert's Rules of Order, a standing rule can be amended by a simple majority. Is there objection from Matt? Seeing none, we're going to take... We'll take your amendment into consideration, Andrew, and I will implement it. So we will begin the trial then and go back to the arguments on the dismissal later. At this time, I'm calling the Judicial Board to order on the specific case of UCSD College Republicans versus Dylan Martin, Paniotis Frusiakis on behalf of the Credentials Committee. My name is Kimo Gandil. I will be the presiding justice today. The decision that we have at hand concerns delegations and specifically charters. I'm required to read out the charges against the defendant, which is violations of the following. CCR Bylaws, Article 3, Section 4. Sorry, I'll begin at the top. CCR Constitution, Article 10, Section 1. CCR Constitution, Article 3, Section 5. CCR Article 3, Section 7. CCR Bylaws, Article 3, Section 2B. CCR Bylaws, Article 3, Section 3. CCR Bylaws, Article 3, Section 4. And those are the ones relevant to the state board. It seems like the other referenced materials come from the UCSD Constitution, but those aren't the charges at hand. And these were gone over in the preliminary, and the defense pleaded innocent to all charges. Is there any objections to the minutes that were prior brought over by the preliminary trial? Seeing no objections, we're going to take those minutes in. Will Kevin please enter that on the minutes when we approved those so that that can be used during the formal documentation of the opinion. Next. Moving on. We're going to be, according to Section 2.18, we took in all of the plaintiffs, so I had the list and it was sent to both of you. Are there any final evidence objections? Seeing as there's none put into the board, we're going to take all those pieces of evidence into consideration, and we'll be moving on to Section 2.2. My name is Kimo Gandil, and once again, I'm the presiding officer. For the record, there are currently 2 justices in attendance, Kimo Gandil, Chief Justice, and Matthew Vitelli, Associate Justice. Mr. Vitelli, will you introduce yourself?
Yeah, hey guys, Matthew Vitelli, Associate Justice of the Judicial Board.
Will the clerk please introduce themselves?
This is Kevin Brum, clerk for the Judicial Board.
There's no acting parliamentarian, so that continues. And we've read the charges. At this time, we're going to be entertaining the plaintiff, who will provide a statement no longer than 10 minutes. Mr. Gates, you have the floor for the next 10 minutes. Mr. Brum, the clerk, can you please record the time? Kevin?
Yes, just one moment.
One moment, Mr. Gates.
All right.
You may make your opening statement.
Yeah, so I'd like to begin by thanking the duly elected and legitimate executive board of the UC San Diego College Republicans for having the will and fortitude to endure what many believe is just a formality for their predetermined expulsion from the organization. Here are the facts of the case. This summer, CCR Communications Director Dylan Martin spread a rumor among the members of both the legitimate chapter and the CCR Executive Board that the UCSD College Republicans had dechartered from the organization. Dylan then submitted credentialing materials for a new chapter at UCSD, using the same membership list, the same constitution, and the same letter of school recognition that were originally submitted by the legitimate chapter at convention. The only difference between Dylan's submitted materials and those of the legitimate chapter was the list of executive board members, which named Dylan as vice president and Drew Olbrantz as president. On June 6th, the Credentials Committee granted Dylan's club an official charter. My argument is simple. First, the UC San Diego College Republicans never even dechartered from CCR. My second point is that Dylan Martin, being neither president nor executive board member of his chapter, had no right to submit new credentialing materials, per both the CCR Constitution and bylaws and the precedent set by previous judicial board rulings. Third, even if Dylan did have this right, the materials he submitted blatantly contradicted his listed executive board. To the first point, there remains no evidence whatsoever that the UCSD College Republicans ever dechartered. As my witness Austin Katz will testify, Dylan Martin first recruited 3 people to his club by claiming that the legitimate executive board had dechartered. However, the only evidence of dechartering that he could procure was a leaked screenshot of the legitimate executive board discussing a motion and informally voting on it via a Facebook Messenger poll. This screenshot is in my folder of evidence, which I submitted at the preliminary. If you read the messages therein, you will clearly see that Vice President-elect Isaiah Henderson and his fellow board members officially decided to postpone any official vote to decharter until their next general membership meeting. This is because Article 7, Section 3 of the UC San Diego College Republican Constitution states that the chapter can only constitutionally decharter via an amendment that is, quote, adopted by a simple majority of the members present and in good standing at a regular business meeting, end quote. Furthermore, while it is true that Michaela McNally's executive board was duly elected and legitimate, it is also true that according to Article 4, Section 2 of the UC San Diego College Republican Constitution, they did not yet have the power to make official decisions, since the board doesn't officially transition in that club until the fall quarter after elections. I'll end on this point by asking how McNally's executive board ever dechartered if they never explicitly disassociated, to quote CCR bylaws Article 3, Section 3. Historically, we have always considered a press release or formal letter to credentials necessary for dechartership. As there was no such explicit disassociation, the Credentials Committee operated on the word of Dylan Martin alone. To the second point, both CCR bylaws and judicial board precedent establish the president of a chapter as the individual in charge of their chapter's chartering materials. According to the CCR bylaws, Article 3, Section 2b, chapter presidents, and I quote, or presiding officers, are defined as the officially recognized officials retaining executive authority over an approved chapter. In CCR v. Steinwender, Kimo Gandal affirms on page 38 that, quote, the president holds ultimate executive discretion in the management of the organization. Cal Lutheran was barred from chartering because their president was barred from the organization, implying that the president alone can charter clubs. This logic was also used in the recent case against board members Sarah Moorcott and Madison Marks Noble and their chapters at SDSU and Chico State. So why was Dylan Martin allowed to submit charting materials for UCSD College Republicans when he was neither president nor president-elect? That power should have been bestowed only onto Jerry Shen, who at the time was president, or Michaela McNally, who was president-elect. To the third and final point, the letter of school recognition which Dylan submitted was granted to Jerry Shen and Michaela McNally's chapter, not Dylan's. The people on the membership list he submitted belonged to Jerry Shen and Michaela McNally's chapters, not his. The Constitution he submitted outlined a history and process by which Michaela McNally, not he, was elected. Imagine if I declared myself president of a new United States and submitted the Constitution as proof. I would be submitting a document that outlines a system of government and elections by which Donald Trump was elected, and Obama before him, and so on and so forth. My proof would be self-defeating. So it's not just that Dylan's chapter at the time of his submission to the Credentials Committee wasn't a chartered chapter, it wasn't even a club. So finally, I want to end on this point. One second, I want to end on this point by saying that if there is any shred of decency left in the Judicial Board, justice will be served and Michaela McNally's chapter will again be recognized. Imagine the precedent this sets. If a rogue member of your chapter were to, quote, start a new chapter, end quote, using your constitution, your membership list, and your letter of school recognition, and the members of the Credential Committee and Judicial Board were friends with the rogue member, what could you possibly do? File a petition against the rogue member with the people who support him? President McNally's initial frustration was understandable. I only ask that you reconsider all of the above and do what is right. After all, fighting for what's right is a CCR motto. Thank you for your time. Oh, I yield.
Thank you, Mr. Gate.
Yeah, I yield my time.
Mr. Brum, how long was that?
He has 4 minutes and 4 seconds remaining. So 6 minutes.
Perfect. For future reference, can you tell the defendant when they have 5 minutes left, 2 minutes left, and 30 seconds left?
All right, I will.
Thank you. All right, at this time, we're pursuant to section 2.3.2. We'll be listening to testimony, and this goes on into the rest of the Judicial Board hearing regulations if you want to go read them. Mr. Gates, who are you calling as your first witness?
Give me one moment, Kimo. I'm looking at my docs.
Of course.
I promise I'm not a boomer. It's just that my laptop's like half broken.
That's fine.
1 second. Yeah, I'd first like to call Michaela McNally.
Perfect. Have her enter. Who is Ryan Patrick, if I may ask?
I have no idea.
That's
that
me,
is-
Pavey. That's Patrick is my middle name.
Perfect. Mr. Pavey, if I could just ask you to log off because we're facing some lag issues right now,
Sure.
and we'll call you later.
Sounds good.
Thank you so much. All right, Mr. Gates.
Point of clerical clarification. How long should be given for questioning of witnesses?
3 minutes for direct examination, 3 minutes for cross-examination.
All right.
And the sworn-in oath that we are required to provide for their due process for witnesses that are not parties of the case pursuant to 2.1.6 doesn't count towards that. Mr. Gates, whenever Ms. McNally is on, we'll swear her in and begin her questioning.
I'm sorry. I had a boomer tech moment. What did you say, like in the last 1 minute?
What? What did I say?
Yeah,
I
like
said,
telling me to do something? My bad.
Just add Miss McNally on, and then we'll swear her in and get to questioning.
All right.
She should be
I texted
shared.
her, or I messaged her. So hold on 1 second. She's trying to find the invitation in the Gmail account.
I can resend it to her.
Okay, okay. Can you message me what email you have?
I have, yes. I'll send her another invite.
All right. I'm gonna resend her email to you so that you have the correct one. I don't know if I deleted a letter or something.
Right. And then just pursuant to the opinion, she needs to have her camera on because it has to be simultaneous oral communication. And that goes for any of the defendants or plaintiffs while they're questioning. It's what is required by the procedural rules.
Michaela said she is on her way to join. Like she's
Perfect.
finding in her email, not that she's not physically at her desk or anything.
All right. If she's not here within the next few minutes, potentially have another witness on the line.
Yeah. I'm messaging someone else just in case that she has to join later.
Sounds good.
Your Honor, I have a question in general. It's just regarding witnesses. How long do witnesses generally have to appear?
Witnesses, according to the Steinwinder president, have 15 minutes to appear.
All right. Thank you very much.
If I believe the witness is being... Yes, if the witness is being obstructionary, though, I can move on. It's within my purview. All witness rulings regarding that is a special rule, so it requires 2/3 of the voting justices on the judicial board to amend the prior precedent.
Okay.
So that would just require Matt and I not having objection.
Okay. Thank you.
My camera
It seems like Ms. McNally. Salutations, Ms. McNally. Can we please, can you turn your camera on pursuant to the standard of simultaneous oral communication? Ms. McNally,
Yeah.
can you please turn your camera on pursuant to the regulation?
Yeah. How do I turn it around? When I turn it on, it's like my back camera.
Is it
What
on the
device do you have?
phone?
I have a Surface Pro.
I mean, in Hangouts there should be. Oh. Jeez.
Take a minute or so. If not, I'm just going to let you go as it is because this isn't particularly important since we're not testing your character. But in the future, we do need that if there's a character test at hand.
On the
And
top,
barring
there should be like,
objections.
on the top, there should be like this little square that has like a triangle next to it, and then you should be able to like push it, and then it should like turn your camera on.
Oh my gosh, I'm hearing so many voices.
Have you tried turning it off and turning it back on again? That was a joke. Never mind.
I laughed. Okay, I can turn.
If you go to the settings at the top of the Hangout, it will give you an option to select which microphone, which speaker, and which camera you want to use. So if you click the gear at the top of the Hangouts, under camera, if you have two cameras, there should be two options for camera.
I feel bad, Michaela. This is my first time using it.
Is someone talking to me right now?
Dylan, your mic is still really bad.
Is it really? This is, I think, the best I got. Does it help if I hold it?
This is not my thing.
Dylan, you're practically completely inaudible to us.
Okay. Let me see if I have another mic.
Your Honor, should we call a 5-minute recess?
Am I on?
Miss McNally, how long do you think it'll take? No, we can't see your form yet.
I can see my own.
Yeah, for the record, I can see her as well. So that might just be
Okay.
a connection issue.
Okay, that's fine. At this time, then, we're going to be swearing you in. Miss McNally.
Your Honor,
Yes,
the plaintiff, the defendant is gone.
the plaintiff? Mr.
The
Gates?
defendant, Mr. Martin.
Oh, the defendant. What happened to Mr. Martin?
He went
Why
to go and
am I-
find a better microphone.
He's gonna be back very soon.
Okay, we'll wait. We'll give him a minute. Otherwise, we're going to begin questioning, and his co-defendant can work out for him.
Very cool. Quick word from our sponsor, Monster Energy Zero Ultra. Quick word from our sponsor.
Mr. Gates, let's keep some decorum.
I apologize.
All right, Mr. Brum, is the defendant... Mr. Gates, let's keep some decorum.
I apologize.
Who's echoing?
All right, Mr. Brum, is the defendant...
Someone's like playing the live stream in the background, I think.
Yeah, it's super annoying.
All right, at this time, we're just going to continue forward. If the co-defendant is not here, he can make that present and known, or his co-defendant, Mr. Frusiakis, can make an objection to that. But we want to get this moving ahead because we have a number of witnesses to interview tonight.
Emo, can you hear me?
Let me pull up my... Miss
No.
McNally, pursuant...
Mr. Martin, I think you have to go into your computer settings and change your default microphone, because I think it's using your laptop microphone even though you plugged in your headphones.
We're all having technical difficulties.
Regardless, we're going to be moving forward at this time, barring objection from Mr. Frusiakis. Seeing no objection, we're going to move forward. Ms. McNally, pursuant to your rights and judicial board procedures under section 2.1.6, we're going to administer you an oath, which requires you to know that you must tell the truth. Please repeat after me. I state your name.
I, Michaela McNally,
Do solemnly swear
do solemnly swear
that I will tell the truth,
that I will tell the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
So help me God.
So help me God.
Thank you, Ms. McNally. At this time, Mr. Gates, you can direct examine your witness.
Oh, I thought I was under the impression that they like speak and then I examine them. Like it's like a 3-minute witness or a 3-minute statement and then I examine or something. Hello?
Yeah, no, Andrew.
No,
The
you
way it
asked the
works is that you're gonna have 3 minutes to ask questions, and Michaela will respond to those questions in that 3 minutes.
Oh, so they don't have a 3-minute opening statement and then 3-minute questions?
No, there's no statement. It's
Yeah, there's
just
no
3 minutes
no
for
opening.
you. Yeah, it's
Okay.
3 minutes for you to ask Michaela questions and Michaela to respond.
Sounds
And
good.
then correspondingly 3 minutes in cross-examination.
Right. From the defendant.
Yes, and anytime you don't use can be brought back in redirect examination.
Okay.
That was a precedent set by Mr. Vitale at the prior trial. Mr. Gates, you have the floor for 3 minutes. Mr. Brum, can you keep the time and alert them at 1:30 and then at 30 seconds?
All right.
Thank you. Whenever you're
Okay.
ready, Mr. Gates.
Yeah. Michaela, I have a few questions for you. So, were you elected president of the UC San Diego College Republicans per the process outlined in your chapter's constitution?
Yes, I was.
Another question. Was Dylan Martin on the executive board at any point before he established his club?
No, never.
Another question. Did Dylan Martin regularly attend your chapter's meetings before he established his club?
No, I was secretary last year. He wasn't even an active member.
Okay. Another question, and you can expound on this a bit more than a yes or no. Did your chapter decharter from CCR via a general membership vote as required per the UC San Diego College Republican Constitution?
No, my club did not decharter. We weren't even in our term yet. We had no official vote whatsoever. We didn't attempt to notify CCR of any vote, and we didn't put out a press release. So no, my club did not attempt to decharter.
Okay, and another question. So you've mentioned in the past that you find the entire trial like stacked against your club. Are there any specific objections you have with this trial that you'd want to share with the justices?
1 minute, 30 seconds remaining.
Thank you.
Yeah, something I find ridiculous and biased is the fact that Chemo, I think that's how you say his name, Chemo, right? The fact that he's the presiding officer, I obviously took this case to the Office of Student Conduct at UCSD, and not only was Chemo a witness and
Objection
defendant.
on relevancy. Why is this becoming about the Chief Justice?
I'm
Ms.
answering the
McNally, I would
question.
ask Ms. McNally, I would ask that you keep it pertinent to the trial, but Mr. Gates, I'd ask you inform you and Mr. Braun, please pause their time or give them time back. You need to keep it relevant to the specific charges at hand. While I understand you may want to make your concerns vocalized, it needs to be relevant to the chartering status of UCSD.
Didn't he ask
Sustain-
me what?
Wait, Chemo, just to clarify, you are saying that you representing Dylan to the Office of Student Conduct at UC San Diego is not relevant to the case?
I'm saying it needs to be made relevant to chartership. If you believe I'm biased or violating an ethics rule, you should have made A, a motion on that, or B, an objection. What I will say is it's normative for an organization to respond to schools asking questions. In no way were we making a statement of fact about a specific case outside of the ruling that was offered by the McNally case. Obviously, pursuant to it, everybody has their due process rights as they're given today. And when the due process rights aren't fully adhered to, then the defense is immediately assumed innocent of the charge and restored of their rights pursuant to the parliamentary rules.
I understand.
At the matter at hand,
Chemo, yeah, I get you. The reason why I brought that up wasn't just to vaguely express general concerns. I think that because one of the rhetorics used against McNally is that because she was kind of aggressive when the first trial was brought up. I think that provides some context just in case that's used by the opposition. But let me just ask you one thing. How do we redirect? You said something about redirecting time. What is that? How does that work?
So any time that you have after this, you can use basically after the cross-examination period to talk to McNally again. Alternatively, if you believe McNally should be, we should hear from her again. The rules permit us to allow you, if the judicial board does not object, to recall Ms. McNally, which is a very common procedure used if you believe she has more to say that's relevant. Now, what I will say in sustaining Mr. Frusiaki's objection is that I understand the context behind it may cause what you believe to be prejudice against McNally, but that can't be handled in the case. What it means is the case cannot be decided regardless of if you believe the defendant or plaintiff on a prior case acted in a way that was malicious or whatsoever. That's not relevant to whether UCSD is a legitimate charter.
Okay, then.
But I understand the concern.
Yeah, I get you. So I can recall her, or sorry, I can say, we'll use the remaining 1.5 minutes in case after Dylan talks that I need to clarify something with her.
Yes.
Okay. I'd like to do that then.
Redirect. Recall is different. That would be asking the judicial board to use a special rule to bring her back and give you an additional 3 minutes.
Okay, well, I'd like to redirect the time so that she can address anything that I think she needs to address after Dylan's speech.
That'll be taken into consideration.
Also, somebody's mic is being...
Is that mine?
Yes, please mute your mic if you're not speaking at this time. All right, that'll be taken into consideration, Mr. Gates. I accept that on your behalf, and I sustain the objection by Mr. Frusiakis. Let's keep it relevant directly to the trial. Equally, I'm going to hold the defense to that, though, too. We should not be talking if you believe the plaintiff has acted prior in a malicious manner unless it directly has to deal with the legitimacy of the chartering materials. It should be held in a different form, not this one. At this time, the defense, you collectively have 3 minutes to cross-examine. Which one of you will be cross-examining, or are you splitting it?
I can lead the questioning, unless...
Thank you, Mr.
Okay.
Well, Dylan, yeah.
Can you guys hear me okay now? Is my mic working?
One moment. Mr. Gates still had 59 seconds remaining in his questioning time.
Yes, I'm going to give him 1:30 because we interrupted him. His line of questioning. So we'll be going back over that. Mr. Isaiah Henderson, I'm just going to ask you log off right now because we're going to begin lagging otherwise.
Yeah, that was my bad. I invited him on because I thought that I got confused about the format. My bad.
All right, we're going to be moving directly onto the cross-examination of Ms. McNally. Mr. Martin, you have the floor for 3 minutes.
Okay, and just, you can hear me okay? Everything's good now?
Yep.
Okay. Michaela,
Yes.
why did you voluntarily dismiss McNally versus Olbrantz?
So that was the previous case that was made for me. I dismissed that because I didn't put in any like wish to have that case happen. I don't know how I can be a defendant or a plaintiff in a case that I didn't ask to be a part of. And also, you guys, CCR administration, made the mistake of accepting false charting materials. So I don't know why it was my job to fix your guys' mistake so you guys could cover your backs. So you could then just say, oh, we made a mistake. Look
Okay.
how...
Sorry to cut
Does that
you off.
answer your question?
Yeah. Okay. So why did you wait 6 months to reopen the issue of UCSD chartering materials?
Well, since you have continued to reach out through emails stating that you're the president of the College Republicans, you continually are trying to recruit my members, ask them if they want to be part of your legitimate club, which is not legitimate. I feel like now is the time that I, as a president of the College Republicans at UCSD, I need to protect my club, my members, my duly elected e-board, and I need to go about doing this case. So,
okay. I mean, I hate to cut you off, but I do have a few more questions I want to
Go
try
for
and get to. Okay. On or within a week prior to June 1st, 2018, did you hold a UCSD board vote to decharter from CCR, yes or no?
no.
Did that vote, okay, let's see. On June 1st, did you state to CCR executive board members Dylan Martin and Drew Olbrantz, myself and Drew, with Rhina and Tiana witnessing in reference to dechartering that, quote, the vote has already passed. Dechartering will not affect our ability to be associated with the Republican Party. We can 100% still use the Republican name. Our club still intends to stay extremely active with the local party and do all the same activism. This is purely a move to establish we no longer want to be affiliated with the state organization. I'm sorry.
Mr. Martin, you have 1 minute and 50 seconds left. I mean, 1 minute and 30 seconds left.
Objection. I thought that the evidence, not that I don't think we can
Pause
address
their
this.
time, Kevin.
I
Sorry,
think,
Andrew, continue.
not that I don't think we can address that terrible argument, but isn't the evidence supposed to be everything submitted at the preliminary? And I mean, I know Pano's a stickler for this, so why hasn't Pano called this out?
The cross-examination period, you can ask them that's something that prior happened. I would say if you wanted to submit a screenshot for impeachment of the witness, it's probably too late to do that. But you can ask them, and then if the witness in theory committed perjury, that would be the case. But you're allowed to ask the witness whatever you wish. Not every single piece of evidence needs to be submitted there.
All right.
But it does need to be submitted if it's a vital part of the case.
Sounds good.
So Sorry,
you.
can you repeat that, Mr. Gates?
Oh, I said that sounds good. Thank you. Allow Dylan to continue.
Okay. The rest of the
Perfect.
quote.
Mr. Brum, can you restart their time? What time was that at?
It was at 1 minute and 30 seconds.
Okay. The rest of the
Continue,
quote.
Mr. Martin.
Yes. The rest of the quote, I'm sorry, the vote has passed. It's no longer in my hands to make the decision. It was a collective decision passed by e-board. We will send a press release out soon, end quote.
Okay, so I kind of forget now what the beginning of your question was. But
Mr. Gandil, can we have time back and repeat the question?
no, it's
Because
fine. I don't need to hear it again because you just read a leaked screenshot that you got. So ultimately, there was no vote to decharter. An e-board private group chat and you somehow getting information from a leaked
yes
chat.
Or no question whether you made that statement to myself or Drew Olbrantz. Did you make that statement?
Well, Drew Olbrantz was not an executive board member, and neither were you. So a private message between us doesn't hold any validity because that is not a.
Did you state? Okay. Did you state in the previous in your
30 seconds remaining
in your motion to dismiss McNally v. Olbrantz? Did you state we would accept no ruling, quote, whether against or in our favor from a body that serves to ensure an illegitimate leadership from consequences, end quote? Yes or no?
Is that from my email? Then yes. I don't know why you're asking me questions about an email that I wrote. Yes, I wrote the email.
Confirm for the record. It's balance of our time.
Mr. Gates, do you wish to direct examine your witness?
Yes.
Mr. Brum, how much time does he have left?
As per your ruling, he has 1 minute and 30 seconds left.
Thank you, Mr. Brum. Mr. Gates?
Michaela, what do you think, per your organization's constitution, what has precedent and what has priority? Your sometimes aggressive messages
Objection,
to other
relevance. The UCSD CR Constitution is not relevant to the chartering materials.
Pause the time.
What? No, come on. How is the Constitution?
Okay, I'm going to make the ruling on that. Dylan, the UCSD Constitution directly, I would say, is in question because it's part of the chartering materials. So I'm not going to sustain that objection. You can continue, Mr. Gates.
Yes. How much time do I have left, Brum?
1 minute and 10 seconds.
Okay. Michaela, my question to you is, do you think what takes precedent in the rulings and the decisions of your organization? Sometimes heated messages that you send to individuals, or the Constitution, which specifically does not allow the president to make dechartering decisions?
I think what takes precedent is the Constitution. But also, for the record, I don't even consider them heated messages. I think I'm telling people what they don't want to hear, and everyone in the CCR administration just doesn't want to believe that they're super biased and corrupt. But yes, constitutions should take precedent. They're not frivolous, and you guys are treating them like they are, and you guys are directly going against them. So that's my answer.
Michaela, I have another question.
Okay.
Are you
30 seconds remaining.
What was that?
30 seconds remaining.
Yes, thank you. Are you the sole arbiter of every decision made by your club, or does the executive board get to make decisions as well?
Me and my executive board make all decisions.
Thank you. I yield the rest of my time.
Thank you, Mr. Gate. At this time, then, we have exhausted the time for this witness. The judicial board would like to thank Ms. McNally for her testimony and would excuse her at this time. Thank you, Ms. McNally, and have a good evening.
Thanks. Thanks, Andrew.
Mr. Gates, will you please bring on your next witness?
Yes, 1 second. I'm messaging him right now.
Am I audible on this?
Yeah.
Yes.
Allow me a second to plug in my headphones. All right.
Can you state your name, please?
My name is Isaiah Michael Henderson.
Perfect. Okay. So, Mr. Henderson, pursuant to your rights, I need to inform you that you are being held to the truth here. So, we're going to be administering an oath to you. If you will please repeat after me. I state your name.
I, Isaiah Michael Henderson,
Do solemnly swear
do solemnly swear
that I will tell the truth,
that I will tell the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
So help me God.
So help me God.
Thank you, Mr. Henderson. At this time, Mr. Gates, you have 3 minutes direct examination on your witness. Mr. Brum, will you please start the time? You have the floor, Mr. Gates.
Thank you, Isaiah. I appreciate the sip. Were you elected a vice president of UC San Diego College Republicans per the process outlined in your chapter's constitution?
Yes, I was elected almost unanimously.
Was Dylan Martin elected vice president of the UCSD College Republicans per the process outlined in your chapter's constitution?
No, as far as I'm aware, Dylan Martin was never elected to any position on the executive board in our organization.
Okay, Isaiah. So I did submit screenshots that your executive board voluntarily released to me as evidence. And in those screenshots, which I referenced in my introduction speech, you explicitly said that that board vote via an informal Facebook Messenger poll was invalid and that you accepted Drew's argument that it should be a general membership vote held in the fall, correct?
That's right. The opinion poll that we took in the executive board chat has no binding validity. According to the Constitution, any vote according to affiliation of in anything, not just CCR, is subject to a general body vote. And me and Drew both agreed that that was, in fact, the correct interpretation of the Constitution.
Okay. I yield the rest of my time for responding to any cross-examination. Redirect my time, that is.
Thank you, Mr. Gates. Mr. Brum, how much time is that?
He had about a minute and 40 seconds left.
All right, Mr. Gates, you're going to have a minute and 40 seconds left. Does the defense want to cross-examine the witness?
No, the defense does not.
Mr. Martin, you do not want to cross-examine the witness?
No.
Thank you. At this time, Mr. Gates, do you want to continue your examination of the witness?
Yeah.
Mr. Brum, please start his time.
Isaiah, so previously, Mr. Martin mentioned that Michaela McNally's messages to private individuals took precedent over the executive board decisions, or he at least implied that fact. Is that true?
No, Michaela McNally made those messages without the knowledge of the executive board and definitely without the assent of the executive board or the general body.
All right. Is there anything else you'd like to say?
Not at this time, no.
Okay. I yield the rest of my time.
Thank you, Mr. Gates. At this time, the Judicial Board would like to thank Mr. Henderson for his testimony. You're going to be dismissed at this time.
All right, thank you.
Thank you, Mr. Henderson. Mr. Gates, will you please call your next witness? Mr. Gates?
Oh, sorry. Yeah, my bad. My mic was muted. Yeah, I'm calling him right now.
Okay.
He said he's getting on.
Your Honor, in the meantime, reviewing some of the minutes, cursory, it seems I have made an error on the timing for the cross-examination of McNally by Martin. The time should have been 3 minutes, but because the time was set for 1 minute and 30 seconds for redirect, I accidentally started that timer instead of the 3-minute timer. So in fact, even though
On who? The cross-examination
on the
or the direct?
on the cross examination. So granted,
Okay.
granted, Martin yielded his time, the remainder of his time, but only after I told him he had 1 minute and 30 seconds remaining. So in actuality, he had
Mr.
1 minute and 30 seconds remaining.
Mr. Martin, do you need more time to cross-examine Miss McNally?
No.
Okay. So just note that, Mr. Brum. Thank you for bringing that up.
Yes, Your Honor.
Austin said it's not letting him join. It's saying, like, please wait or something. Can you hear me?
Yes, sorry. Austin, what is Austin saying? Please wait.
No, he's saying that when he tries to join, it says please wait.
Okay, I'll try adding him again. What's his email? Can you DM me his email again?
Yeah.
Andrew, I had the same problem when I was trying to log on, and I found that it helped to go on Google Chrome to do that. So a different browser might.
Oh, there he is.
Sorry, y'all.
Mr. Austin.
Yes, Your Honor.
Please see your picture, sir. Requirement under simultaneous
Okay.
rule communication.
I'm seeing my picture, but I don't know how to turn it on.
I'm seeing it too.
I'm seeing it.
My computer might just be acting oddly. It's mostly for the defense then.
I think it's
No
All
worries,
right,
Your
at
Honor.
this time, Mr. Austin, it's my requirement to tell you that you're required to tell the truth ethically to this formal hearing pursuant to section 2.1.6. All witnesses shall be informed of their obligation to tell the truth prior to presenting testimony. Therefore, I'm going to be administering an oath to you, swearing that you will be telling the truth to the judicial board. Please repeat after me. I state your name.
I, Austin Katz.
Austin?
Hello?
Yes.
Yeah.
So repeat after me. I state
Oh.
your name.
I, Austin Katz.
Do solemnly swear
Do solemnly swear
that I will tell the truth,
that I will tell the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
So help me God.
So help me God.
Thank you, Mr. Katz. At this time, Mr. Gates, you have 3 minutes to direct examine your witness. Mr. Brum, please set the time.
All right.
Mr.
Begin when
Gates,
ready.
whenever you're ready.
My bad. I was on mute yet again. Austin, is it true that you were elected treasurer of the UC San Diego College Republicans per the process outlined in your chapter's constitution?
I was not elected, but yet appointed for a vacancy by Chairman McNally and approved by the e-board. But yes.
Okay, thank you. And is it also true that Dylan Martin had initially, when he broke off from your legitimate chapter, attempted to recruit you for his chapter?
That is correct.
And what did Dylan tell you were the reasons why you should join that chapter?
Dylan told me specifically that the UCSD CR chapter dechartered officially, and we were defunct. And since I'm a committed member of CCR and an active member, in order to join the legitimate chapter, I had to join his newly formed e-board.
Okay, I yield the rest of my time until Dylan cross-examines. Thank you, Austin.
Thank you.
Will Mr. Brum set that time? How much do they have left?
1 minute and 55 seconds.
Thank you, Mr. Brum. Mr. Martin, you may cross-examine.
You in the club before someone, or?
I can't hear anything.
One moment.
Sorry, I was conferring with Pano. No questions at this time. I'll yield to Andrew.
Mr. Gates, would you like to continue questioning your witness?
Yes.
You may proceed.
Austin, could you give a quick summary of the reasons why you decided that Dylan Martin's assessment of legitimacy and the chartership of your club were incorrect, and the reasons why you didn't end up joining his organization permanently?
Well, I initially joined Mr. Martin's organization because I thought it was the legitimate chapter and we dechartered, and I wanted to participate as a committed member of CCR in state activities. However, after discussing with Michaela, who was in my history class, I found out that we did not actually decharter, and I took extreme objection to the hostile takeover of the rightful UCSD e-boards chat, and the e-boards thing, and I had extreme objections to that. And really, I was skeptical at first to pick sides because I'm friends with both people. Dylan, Your Honor, Chemo, Pano, they're all good friends of mine. I made great memories at CCR, and I didn't want to lose those. However, it called on to me to make a right decision, and I have extreme objections into how my friends were other friends from UCSD were treated, and I wanted to stand up and do something
30
right.
seconds
So
remaining.
no, I was not going. Yeah, that's it.
Okay, thank you, Austin. I appreciate it, and I yield the rest of our time.
Thank you, Mr. Gates. Mr. Katz, I do have a few questions for you, just pursuant to 2.3.6 of the Judicial Board hearing. Some factual questions.
Sure, Your Honor.
You seem to have been on both sides of this. So you were at one point a member of both boards, to call them in an informal manner.
Yes, Your Honor. I told Mr. Martin at the time that I was a part of his board because I thought it was the legitimate one at the time. And then I switched to Michaela's board after doing some consideration. But yes, Your Honor.
So my main question here has to do with the existence of two clubs on the campus. Was the discourse that went between you and Mr. Martin, was that in regards to claiming of a single title, College Republicans, or was it two different distinct clubs, i.e. a different name, for instance, or something along those lines?
Well, you correct me if I'm wrong if I'm answering this question, but from what I understood, it was one singular name. Mr. Martin told me multiple times that Republicans is trademarked through the CRNC, and since they have the official name, therefore they are the legitimate chapter. So they were always two separate clubs, but it was always the contention of Mr. Martin's chapter that they were the rightful heirs of the name, and when the university ruled in Michaela's favor about taking the name, that is when that they only talked about a new name.
So I understand the legal question behind it. Perhaps it's more of a practical. Would you say they're
Okay.
two distinct entities, i.e., their composition, etc., their practicalities, logistically? Would you say they're two different entities, or are they kind of both battling for the same people?
In my eyes, they are two separate clubs. However, Mr. Martin's board was competing for the same members and status of the old club. So there are technically two clubs, but the newly formed club was battling or taking over what was the old club's territory. So I don't necessarily know how to answer that question.
No, that's fine. I was more interested on the factual nature of what the on-the-ground situation of UCSD looked like,
Yes.
from somebody who's been on both sides. But I thank
Yes,
you
and
so much.
And can I say something, Your Honor?
Yes.
And to add for that, for the record, the Mr. Martin's club didn't have much of a campus presence because all of the logistics talking were to set up the entire club. There was no precedent, unlike Ms. Michaela McNally's, about campus presence, as they say.
Yes,
So
of
that's
course.
all I yield the rest of my time. Thank you, Your Honor, and may it please the court.
Thank you, Mr. Katz. Mr. Gates has yielded the rest of his time as well. So the Judicial Board would like to thank Mr. Katz very much for providing this compelling testimony. And at this time, you're going to be excused.
Thank you.
Thank you so much. Mr. Gates, would you like to call your next witness?
Yes, one moment. She's working on getting on right now. I apologize.
Would it please everybody, we can have a 2-minute recess so I can run to the restroom.
Yeah, that's fine.
Sounds good.
Yeah, that's fine.
We
Kibo,
will.
Could we make it 5 minutes? Just take a break.
Yes.
Thank you.
So we will. The Judicial Board is going to take a 5-minute recess, and we'll meet back at 8:15.
Thank you.
Andrew, can you see me?
Yeah, but we're taking a 5-minute recess.
Okay.
this. Hello, right? I'm calling the judicial board back to order. Just to make sure everybody's here, the defense I can see is here. Mr. Gates, are you present?
Yes.
Perfect. We're going to be, at this point then, moving on. Who is your next witness, Miss Leslie?
Yeah, Leslie Garcia.
Ms. Garcia, pursuant to section 2.1.6, I must inform you of your obligation to tell the truth prior to presenting testimony. For that reason, we're going to be giving you the oath. Please repeat after me. I state your name.
I, Leslie Garcia,
Do solemnly swear
do solemnly swear
that I will tell the truth,
that I will tell the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
So help me God.
So help me God.
Thank you, Ms. Garcia. At this time, Mr. Gates, you may direct examine your witness.
Okay, thank you. So, Leslie, you're on the credentials committee, correct?
Yeah.
Let me ask you, was there any coordinated effort to charter Dylan's club that potentially resulted in Dylan submitting the materials McNally's chapter possessed, like the same membership list, the same constitution, etc.? And were you told that UCSD CRs had dechartered? If so, by whom?
Yeah. So there have been 2 instances in which Dylan has submitted essentially stolen chartership materials. The first instance occurred in June, right after the deployment, the Newman deployment. On June 4th, Chairwoman Rollins claimed that UCSD had submitted updated materials.
What? It's
Matthew,
whether UCSD is a
mic.
legitimate club. I can tell you about it later.
Matthew, mute your mic, please.
Yes. Anybody who's not directly in, please mute their mic. Mr. Brom, please put 10 more seconds back on the clock. Miss Garcia, please continue.
Okay, so on June 4th, Chairwoman Rollins claimed that UCSD had submitted updated materials, which was a lie because the materials which Dylan submitted were Michaela's membership list, and he fabricated an exec board, and he submitted their constitution, and she wanted to push this vote through after the Newman deployment. Now, the second time in which Dylan submitted fabricated materials occurred just last month, I believe. We voted on it in the credentials committee. I looked through Dylan's membership list, and 40 names were completely copied and pasted off of Michaela and Jerry's original membership list. And I let the committee know that I viewed this and I thought it was an issue, but they didn't care.
Mrs. Garcia, can you please, sorry, Miss Garcia, not Mrs. yet. Can you please expand on the fact that other members of the credentials committee, like, what was their response to your objections?
At first, there were a couple of people who thought that we should look into this a bit more, but once the vote was called, they did not vote in line with this suspicion that they had. Instead, they voted to just push through this chartering.
Thank you. I yield the rest of my time, and I defer it or redirect it, whatever it's called.
Thank you, Mr. Gates. Mr. Brom, how long does he have?
38 seconds.
Thank you, Mr. Brom. At this time, we'll then be taking cross-examination. Would the defense like to provide cross-examination?
Yes.
Mr. Frusiakis.
So, Ms. Garcia, how does Dylan go about submitting falsified materials if we are the committee?
You literally copy and paste materials that do not belong to you.
And did we discuss this thoroughly through our last credentials committee meeting?
Yeah, and if you remember, a member of the committee said, yeah, this actually sounds interesting and we should probably look into it. And when the time came to vote, he voted in line with you.
And did we thoroughly go through the entire Constitution and the code? And did I abide by all of parliamentary procedure to make sure you were able to express exactly all the problems that you thought were necessary and everything that you just gave in your testimony?
I guess.
Yes, thank you very much. Alrighty. So that's honestly going to exhaust my questioning.
Thank you, Mr. Frusiakis. Mr. Gates, do you wish to continue your line of questioning?
Yes.
You have the floor.
Leslie, does giving you the proper parliamentary procedure to allow you to voice your opinion absolve somebody of being negligent or intentionally malicious in like just dismissing your claims of fraud?
Absolutely not, because there was no investigation or there was no he showed no intent that he cared about this fraud.
Thank you. I'd like to yield the rest of my time.
So I have a couple questions. Miss Garcia, you make this claim of intent, which has to do, it's a character claim. What is the evidence of the claim of intent you're making? So not the factual claim of the occurrence, but the intent of it.
So when I'm speaking of intent, I'm talking about the second situation in which we voted on credentialing UCSD. And in this situation, as I said, I noticed that Dylan's membership materials had copied and pasted 40 names off of Jerry and Michaela's membership list. And a lot of the people on this list had either already graduated or they had entirely distanced themselves from Dylan's club. And I know this because I spoke firsthand with people at UCSD who obviously like they are friends with people, other college Republicans, whatever. So when I brought this up at the credentials committee meeting, I think it occurred in November, the chairman and other people in the committee, they did not care that I had brought up this situation and they did not care for investigating it. And instead they voted, they pushed through the vote for credentialing Dylan's club. And I think that that shows that they had no intent of investigating these materials and whether they were fraudulent or not.
So you would say that the act itself portrayed intent, not a specific instance or phrase used or something of that sort.
Yes, the act itself.
Thank you, Ms. Garcia. I don't have any further questions. Mr. Vitale, do you have any? Seeing none. Thank you, Ms. Garcia, for your testimony. The Judicial Board thanks you for
Your Honor. Your Honor, I have a question. Is there some kind of mechanism by which, if we hear a blatantly false testimony, that we can briefly be able to correct it?
Yes, if you believe.
Yeah, it's just a very quick kind of fact. It's just that the witness just stated that she came to a meeting in November, the credentials meeting, but she never was even there. So I don't know how she corrected it if she wasn't there.
If you believe, so there's two different parts to that question.
She came to the last one, but not the one in November.
Mr. Frusiakis, one moment. The first one would be if you believe the witness perjured herself, in which case you would move to impeach the witness. If you believe the witness just stated something off the record incorrect, you should ask that during cross-examination. But unless it's a perjury claim, I would not recommend.
Can I clear this up, because I did make a mistake. I actually meant the credentials meeting in December. I got the date wrong. I'm sorry.
All right. Thank you for clarifying that, Ms. Garcia. Mr. Brum, I'm sure, can keep that on the record. And of course, it's recorded here. Thank you so much, Ms. Garcia. Your testimony was compelling.
Thanks.
Have a good night. The Judicial Board excuses you. Mr. Gates, will we call on our next witness?
Oh wait, was my mic on mute that entire time?
Yes.
Oh shit, my bad. I mean, shoot. Yeah, I'm calling them right now.
Thank you, Mr. Gates.
No problem.
Your Honor, I had a question. Pano had about 2 minutes or so remaining from his questioning. Can he redirect?
Redirect
After?
cross-examinations allowed.
Okay.
Matt doesn't
okay.
object to it.
All right.
I'm sorry. What was that about?
Redirect cross-examination. Not usual, but
Yeah, that's not usual. It's fine. I think it makes sense as long as whatever party has time left in their cross examination. One thing that is something that everybody should be aware of if we're gonna go down that road is that with each successive examination, your scope of questioning narrows. So one thing to keep in mind is that your direct examination, you ask questions on the entire set of facts. Cross-examination asks questions about that set of facts that was asked about, again, about that entire set of facts. When you do a redirect examination, it's solely on what is covered in the cross-examination. And so when you do when you do a recross, that's only going to be pursuant to what was covered in that redirect examination. So we can allow them. I have no problem with them procedurally, but just know they're not exactly very effective, just because the scope of questioning is so limited.
Yeah, I was just wondering because when Pano wanted to question the witness about that, I was just wondering if he could have used the remainder of his time to redirect.
yes, but usually
he could have. Yeah.
We usually also want that before we move towards the judicial board asking questions in 2.3.6 procedurally. So that'll be best for that. We seem to have our next witness present. Mr. Gates, which one is this?
Okay, so we're calling Tiana first and then Ryan next because they are two individuals.
Yes, sir. All right. How do I pronounce your last name, Miss Tiana?
Tiana Menezes.
Menezes. So I am required, pursuant to 2.1.6, to inform you of your obligation to tell the truth prior to presenting testimony to the judicial board. At this time, I'm therefore going to be asking you to say this oath. Please repeat after me. I state your name.
I, Tiana Menezes.
Do solemnly swear.
Do solemnly swear.
That I will tell the truth.
That I will tell the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
So help me God.
So help me God.
Thank you. At this time, Mr. Gates, you may begin direct examination of your witness.
Thank you, Tiana. First question, what position do you hold on the executive board of the UC San Diego College Republicans?
I am the secretary of the UC San Diego College Republicans for the year 2018-2019.
Okay, and what do you know about the informal opinion poll that was taken in the executive board chat that Mr. Dillon refers to?
I know that it took place on a Friday, I think in the afternoon, and it was very poorly done, and I did not submit a vote in the actual poll that happened. So it is not count. It is invalid, and it is should not be counted.
Okay. Another question, what role did you have in the California College Republicans? I know that you were on the same position.
I was part of the CCR Public Relations Committee.
Thank you. And what sort of communication did you have with the chair of that community when this was going on?
I would say we were friends, pretty friendly. We had no problems.
Okay, and what did Mr. Martin tell you about the situation while you were on the credentials committee, seeing as his rhetoric would mean that you were an invalid member, correct? You couldn't hold a position?
So let's go back a bit. This vote happened Friday afternoon, and then in the evening at around 10 p.m., I would say, he sent a message to Michaela Drew and asked
1 minute, 30 seconds remaining.
And asked us about this. So he came to us to talk about the vote. And then he also came to us, asked us what is for if we are admins of the Facebook page, and he asked us what he asked us to be a part of his board. And then when he actually took over our club on this Tuesday, he begged us to be a part of his new board twice. And then he, after we did not respond, he kicked us out of the credentials committee as a direct response. The public relations committee. I'm sorry, public relations committee as a direct response for us not being registered college Republicans because we dechartered, which we did not.
Okay, and was Dylan alone in trying to convince you to join his club?
I do not know.
30 seconds remaining.
On Friday night, when he messaged me privately, he asked me if I could quickly hop on a call with him and Ariana. That's what I know.
To discuss what?
The dechartering situation.
All right, thank you. I yield the rest of my time.
Thank you, Mr. Gates. Mr. Brum, how much time do they have left?
7 seconds.
Okay. Will the defense wish to cross-examine the witness?
I do have a couple questions, I think.
Mr. Dylan Martin, you have the floor.
Okay. When you mentioned that I don't want to quote you wrong, kicked you out of the Public Relations Committee, did I essentially kick you out, or were you suspended?
Suspended.
And is being suspended within the purview of the chair of the Public Relations Now Marketing Committee?
You did not. I'm sure it is, but you did not give me a warning. As soon as you sent the message, you took me out of the pool.
Okay. Did I approach you both later and apologize and ask you to come back on to the board?
Very diplomatically after seeking advice from legal counsel.
Okay. No further questions. Also, happy holidays, but no further questions.
Merry Christmas.
Let's stay in decorum, everybody. At this time, Mr. Gates, you can't really use your last 7 seconds, so unless you wish to move to recall the witness.
No, I want to move on to the next witness, who is Ryan, and she's on the stream, so we don't have to have an intermission.
Excellent. At this time, thank you, Mr. Tiana, or Mrs. Tiana. The judicial board excuses you.
Thank you.
Yes, of course. Miss Rihanna now.
It's pronounced Ryan Menezes.
Yes, I apologize. One moment. Ryan, am I pronouncing that correctly?
Yes.
Pursuant to 2.1.6, all witnesses shall be informed their obligation to tell the truth prior to presenting testimony before the judicial board. So just to quickly go over it, we're going to administer an oath to you. Please state after I state the oath. I state your name.
I, Ryan Menezes,
Do solemnly swear
do solemnly swear
that I will tell the truth,
that I will tell the truth,
the whole truth, and nothing but the truth.
and nothing but the truth.
So help me God.
So help me God.
Thank you. Mr. Gates, you may begin direct examination of your witness.
Hi, Ryan. Thank you. Did everyone on the board for the College Republicans at UCSD vote in that leaked opinion poll?
No, not I. I didn't vote. Yana didn't vote. The former chair who has to get a vote on these things, he didn't vote. And Drew voted, but Drew surprisingly voted, but he was not an official board member.
Okay. And did you believe that the people who did voted, or sorry, that was incorrect. The people who did vote, did they hold a proper vote? Was that a legitimate vote to decharter?
It wasn't a legitimate vote. It wasn't. The motion wasn't even seconded. Like, it was just, hey, we want to do this. And some people said yes, and we were like, hey. Initially, we were in disagreement of the charter, which is why we didn't vote in the poll. it was very haphazard. It was basically an opinion poll on a Facebook group chat.
Okay, thank you. I yield my time for cross-examination. Or I redirect my time.
Thank you, Mr. Gates. We'll now be moving on to cross-examination. Does the defense wish to cross-examine the witness?
The defense relinquishes the time. We don't. No further questions.
Thank you, Mr. Martin. Mr. Gates, do you wish to continue questioning?
Yes, Ms. Ryan, does President McNally's private messages to other individuals, does that hold precedent over a constitutional formal club vote to amend the Constitution to charter?
No, if the president acted alone, she should have consulted the board before moving forward and making any statements. There was no case.
So as you understand it, and as the rest of the board understands it to the best of your knowledge, no one considers that vote legitimate on the executive board?
Nobody. We, in fact, the vote took place Friday afternoon, but then Monday night, we basically said, you're right.
1 minute 30 remaining.
Sorry?
I said you had a minute, now 25 remaining.
All right, so yeah, the vote took place Friday afternoon, but then Monday night, after Drew brought up that we didn't conduct a vote in a constitutional manner, we like, yeah, you're right. We reversed the decision and we said, okay, let's wait till fall quarter to actually have a proper vote.
Okay, and my last question, it seems that a lot of the people, well, not a lot because there weren't a lot of people, but the entirety of the people who originally defected to Dylan's club, it seems as if many of them, including our witness Austin, defected because of a confusion about whether they be chartered or not. What can you say about that regarding the 3 members who originally defected to Dylan's club and established it?
I know they were given wrong information, and it could possibly be because Dylan initially stole our club's official Facebook accounts. So they were using our access to our members to let them know, hey, they're the official club, when they weren't. We were the official admins of the club, but they kicked us out.
Are those members who originally defected
Time has
still part of
expired.
Dylan's club?
Time has expired.
Please make the final statement very quick.
Yes, my question is, are the members who defected to Dylan's club, to the best of your knowledge, are they still with this club, or have they expressed to you that it was all due to confusion?
Please make it quick.
It was mostly due to confusion.
Thank you. Mr. Gates, do you want to recall your witness?
No, I'm good.
Thank you. Thank you, Miss Rihanna, for your time. Rihanna, your testimony was compelling. The judicial board therefore thanks you and excuses you.
Thank you.
Mr. Gates.
Mr.
Yes.
Gandol, can we take a recess? I have to get a charger because my laptop's about to die.
Yes, we're going to take a 5-minute recess. Is there an objection by Mr. Vitale? Seeing none, we're going to take a 5-minute recess. We'll come back at, let's just have an even time. Let's just say 8:45.
Thank you.
We are in recess.
Your Honor, I had a question. Kimo. Or Matthew, either one.
Yeah, what's up?
So in that case, where we had 2 witnesses who were coming from the same live stream, at certain points they were talking to each other, giving each other some clarification on information. Are there any rules in CCR, I don't recall off the top of my head, about coaching witnesses and people talking to the witness?
No, I mean, it's bad form, but we don't have anything codified about that.
Okay,
I see nothing wrong with it. I mean, in the rules, in the federal rules, you do see instances where, for example, if a witness is about to testify to something that they have absolutely no knowledge of, or absolutely no recollection of, an attorney can pause the record and refresh his witness's memory. And that is something that's reflected in our rules of evidence. But I honestly, I mean, like I said, it's bad form, but there's nothing specifically codified that witnesses can't talk to each other.
Okay, I was just curious because just curious as to the differences and finer delineations between CCR law and normal law.
Yeah, I mean, we follow the federal rules fairly closely, actually extremely closely, but there's nothing specifically codified. I'm not sure actually that that's codified in the rules of in the rules of evidence. I think that might just be a broader in some other aspect of the federal code. But I don't think.
Clear.
What's that?
Those rules were struck.
The CCR rules of evidence.
No, not all of them. The rules regarding witnesses talking to each other.
Oh, right.
It only references justices talking to people outside of the formal trial. But justices can talk to each other, obviously. That's how deliberation works.
Right.
And, of course, their staff.
What I was asking was specifically witnesses talking to each other during testimony, not witnesses talking to each other outside the trial.
One moment. I'm going to be getting a different chair because this one's unfortunately breaking.
There's still about 25 seconds remaining on the recess.
All right, I am back. Is everybody back? Is the defense back and the prosecution? Mr. Gates, Mr. Frusiakis.
Yeah, I'm here. What's up?
Yep.
Excellent. Mr. Vitale, Mr. Brum.
I'm here.
Here as well.
Perfect. All right, I'm calling this meeting back to order. 8:45. Mr. Gates, we're going towards your next witness then.
Let's see. I don't think I have any more witnesses.
Excellent. Then
Yeah, I don't.
the plaintiff rests.
Yes.
Excellent. We will be calling then the defense at this time. The defense may have their opening statement pursuant to 2.4.1.
Thank you, Your Honor. Let me know. Is my time starting?
Mr. Brum.
Just one moment.
I'm sorry, Dylan. Before you start, does anybody not have headphones in? Because there's an echo. There shouldn't be.
Are you still hearing that noise?
No.
No, that's much better.
Yeah, it was weird. There was an echo for a minute and then it stopped.
Okay. So, we good to proceed? Or-
Yes.
Okay, just let me know when my time's starting.
Begin when ready.
Okay. Your Honors, I am Dylan Martin, President of the Republicans at UCSD, and I'll be representing myself and Credentials Committee Chairman Panagiotis Frusiakis in the opening statements. We, the defense, have been charged with revoking the permanent charter for UCSD, for considering college Republicans at UCSD dechartered, for submitting illegitimate chartering materials on June 3rd, 2018 and November 27th, 2018, and for accepting and approving illegitimate chartering materials on June 4th, 2018 and December 6th, 2018. We will present evidence to you that shows the chartering materials submitted are legitimate and that the Credentials Committee verified them according to Credentials Code and other relevant CCR rules and procedures. The plaintiffs would have you believe that a grave injustice has occurred, that their chapter has been ripped away from them. However, their rhetoric does not pass muster when confronted with facts. Fact, theoretically proving chartering conduct in June was improper does not change the fact that a new club is recognized for CCR now, Republicans at UCSD, and thus a portion of the plaintiff's argument is now irrelevant. Fact, college Republicans at UCSD can continue to operate at UCSD without being chartered with CCR. Fact, CCR's rules and procedures were followed by the Credentials Committee as evidenced in their minutes. Fact, Republicans at UCSD is a new club, and the plaintiffs cannot interfere with its internal operations. Fact, Republicans at UCSD is registered with UCSD. Fact, Republicans at UCSD is currently chartered with CCR. In fact, only one club on campus can be chartered with CCR at a time. In fact, Ms. McNally has had the chance to correct these alleged injustices in June/July under McNally versus Olbrantz. As your honors are aware, the plaintiff voluntarily dismissed their own case, choosing not to seek to have their charter restored. Bringing this issue forward again has created the issue presented in the judicial board's opinion on that case. Quote, the ends, it does seem, is that if McNally, a representative of the plaintiff, wishes to pursue a future case, she is caught in a legal double bind. Either she admits her case had merit and was dismissed without good cause, or she believes her case had no merit, and at which point the defense would immediately claim innocence, end quote. Clearly, either being chartered is not important to McNally and she is pursuing this for political reasons now, or being chartered was important to her, but she didn't have it in her to fight for it for whatever reason until now. The timing is convenient considering Ms. McNally waited 6 months until a new club was chartered to bring up the issue again. We can only read this case then as an attempt to spite us for having the gall to start a new club on campus. The heart of our argument is that Republicans at UCSD is a new and separate club than that of the plaintiffs. Formed in November 2018, Republicans at UCSD is, as you can see in our evidence, registered with UCSD as an official student organization. Please see our student organization webpage listing our organization as active, as well as email exchanges with advisors, room reservation requests and confirmations, and our letter of school recognition to verify this. It is simply unquestionable that Republicans at UCSD is registered with UCSD when presented with this proof. And Republicans at UCSD is no more or less official than college Republicans at UCSD, contrary to what the plaintiffs have alleged. The process for registering with UCSD is the same for any club. You must have at least 5 members who have attended UCSD leadership training and a club constitution. UCSD does not differentiate between the level of officialness of its registered clubs. Both college Republicans at UCSD and Republicans at UCSD are registered with UCSD, having met the same requirements. Having 2 clubs on campus vying for recognition by CCR could potentially trigger the 1 club per campus constitutional requirement, sparking a board vote. However, we're just here to argue that our chartering materials are legitimate and thus the standing charges are without merit. Today, you will hear from myself, Republicans at UCSD Vice President Jordan Jarvis, Credentials Committee Chairman Panagiotis Frusiakis, and Credentials Committee members Christopher Casillas and Ryan Pavey. Together, we will verify the legitimacy of Republicans at UCSD and the process by which the Credentials Committee allowed our chartering amendments. To help prove this, I will also go through the charges one by one and link them to our evidence, proving the contrary to the plaintiff's claims. Charge 1, CCR Constitution, Article 3, Section 5, for revoking the permanent charter of college Republicans at UCSD, then under President Jerry Shen and President-elect Michaela McNally by means other than those specified under CCR Constitution, Article 3, Section 7, end quote. No charters were revoked until Ms. McNally petitioned CCR for recognition, sparking McNally versus Olbrantz, as per administrative guidance issued by the Office of the Parliamentarian to the Credentials Committee prior to McNally v. Olbrantz. UCSD's charter was revoked/suspended pending trial. When the plaintiffs dismissed their own case, the charter and associated privileges were restored to Olbrantz. The previous meeting minutes from June 4th and December 6th, see those minutes on June 4th and December 6th to verify that UCSD's charter was amended, not revoked. This amended version of the charter was
5 minutes remaining
with the ruling of Judicial Board in McNally versus Olbrantz. Thus, the most current executive board for UCSD prior to the December 6th update included myself, Dylan Martin, as an executive board member. Charge 2, CCR bylaws, Article 3, Section 2B, quote, for accepting new chartering materials from Dylan Martin, who is neither president nor executive board member of his chapter, and thus could not have been the recognized officials retaining executive authority over an approved chapter as approved by the then established chartership, nor the one with executive discretion over chartering materials, CCR v. Steinwender, page 38, end quote. The specific date for this incident is not mentioned in the charge. However, I will address both circumstances it could pertain to. 1, the chartering amendment petition on June 3rd, in which Drew Olbrantz, Sarah Garcia, and I requested that the Credentials Committee amend UCSD's charter. In this issue, I was acting as a proxy for Drew Olbrantz to submit the petition, of which I was going to verify with him in cross-examination, but he did not appear as a witness for the plaintiff. Drew and Sarah were on the executive board for UCSD at the time, thus possessing executive authority over chartering. 2, the petition to the Credentials Committee to recognize Republicans at UCSD on November 27th, 2018. If your honors reference our evidence list, you will see the organization's registration page listing myself as the sitting president of Republicans at UCSD. This gives me executive authority over chartering, as well as the fact that I was previously listed as an executive member on the chartering materials for the other club. Charge 3, CCR bylaws, Article 3, Section 3, quote, for considering the college Republicans at UCSD dechartered at Dylan Martin's insistence based on mere rumors and leaks rather than the duly elected executive board's explicit disassociation or a legal vote by the general membership to decharter per the UCSD CR Constitution, Article 7, Section 3, and Section 5.2, end quote. If your honors would reference the Credentials Committee meeting minutes provided, it is clear that the charters were amended rather than revoked or considered dechartered. Because UCSD was not considered dechartered at any point formally, this charge holds no merit. Charge 4, CCR Constitution, Article 10, Section 1, quote, for accepting a membership list, a list of executive board members, a club constitution, and a letter of school recognition that conflicted with the existing chapters, historical elections, official documents, and status with the university, thus rendering them internally inconsistent, end quote. This charge, we surmise, is an attempt to delegitimize the legal process Republicans at UCSD went through to charter with CCR on November 27th/December 6th. As will be presented in witness testimony, Chairman Frusiakis was made aware of the chartering materials were for a new club. And as I had the executive authority to handle chartering for UCSD prior to December 6th, as well as standing in the new club, this move to allow new club registration was essentially authorized by myself. Chairman Frusiakis and the Credentials Committee, as you will see, verified the legitimacy of all submitted materials in accordance with CCR's rules and procedures. At the end of the day, this case boils down to facts and law, whereas the plaintiff will attempt to hang us on political and emotional arguments. It is our duty, however, to study and account for these facts, and the fact of the matter is that the plaintiff's charges hold no merit, and Republicans at UCSD is a legitimate force on campus at UCSD, formed and chartered under all legal rules and procedures, both at UCSD and within CCR. Thank you. Yield the time.
Thank you, Mr. Martin. At this time, we'll be hearing from your first witness. Who is the first witness you are calling?
I'm assuming that would be me.
Mr. Martin, I can't hear you.
Oh, sorry, I had muted my mic. I was trying to find the window. I was going to call Jordan, but Ryan, we could do you as well if Pano, if you're willing to do the questioning.
Okay.
Yeah, I'm
Gonna
totally
question the dog as well.
Perfect. Mr. Pavey, all witnesses, I must inform you, shall be told of their obligation to tell the truth prior to presenting any testimony to the judicial board. It is for that reason I'm going to administer this oath to you. Please state as I do. I state your name.
I, Ryan Pavey,
Do solemnly swear
do solemnly swear
that I will tell the truth,
that I will tell the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
So help me God.
So help me God.
Thank you, Mr. Pavey. Mr. Frusiakis or Mr. Martin, you can begin your direct examination.
All right, I'm going to take care of the questioning here. Okay, Ryan. So, did we as the Credentials Committee debate the merit of Dylan Martin's membership?
Yes, that is correct.
All righty. And do you feel that various perspectives were considered by the Credentials Committee when we debated the merit of his materials?
Yes.
All righty. And in your opinion, did Mr. Martin's club materials adequately meet the 4 criterion that are listed in the Credentials Code for a charter to be approved and accepted by CCR?
Yes.
All right. Well, thank you very much then. That is going to exhaust my questioning for the time being. And I'm going to now open it up to, what's the official term, Your Honor? I forget for...
Redirect.
Yes, exactly. Redirect the question.
Redirect.
Yes.
All right, thank you, Mr. Frusiakis. Mr. Gates, you may cross-examine the witness. Do you wish to cross-examine the witness, Mr. Gates? Your mic is on.
No, it's off.
Or off, sorry.
Someone's playing like really loud music. All right. Okay. Yes.
You may begin when you wish.
Hello, Mr. Pavey.
Hello.
So I'd like to expand on what Pano said exactly. So when he says that the Credentials Committee considered multiple opinions, was there any debate to be had, or was this more like, Leslie, the dissenting member, stated something and then Pano ignored it? What is more similar?
Oh, no, there were several different perspectives that were brought up and debate from multiple members, myself included.
Can you mention some of those different perspectives?
Yes, this is referring to the San Diego. Let me brush my memory.
The recent meeting.
The recent meeting, yes.
Yeah.
Me and another board member, Credentials Committee member, had some questions as to the vetting of the members on the list. However, we discussed that and if that could possibly be an issue. However, we didn't come up with anything in the bylaws that asked for that, and so we made our decision based on the fact that we couldn't find any bylaws asking for the vetting of the list as long as it met the criteria.
Okay, so what specifically was the objection to the membership list presented by Mrs. Garcia?
If I remember correctly, the objection was that the list was very similar to that of
1 minute, 30 seconds remaining.
UCSD club. I believe that was what was brought up.
And besides Leslie, were there any people who agreed with her?
That's kind of a hard question. I wouldn't say agreed. I believe people were there were people that were curious or wanted to look more into it.
And did you guys look more into it?
No, we did not, as the list did meet all of the criteria, but we also agreed to look into this in the next credentials meeting and decide what how similar situations should be handled in the future.
Okay, so what was the rush? Like, why didn't you just wait until the next meeting if you guys had contentions and you weren't really sure how to handle it? Why did you handle it?
We discussed that, but we decided to press forward since it met the criteria that were outlined in the bylaws already. So we didn't feel that there was a need to wait. But we did agree in the future to look into this issue.
But you admit that there's something worth looking into?
Yes, it's worth looking into this situation.
Why is it worth looking into if there's nothing in the bylaws that specifies that?
In my opinion, it just seems like it's a potential gray. It's kind of a gray area where if it matters or not, the members that are outside of the criteria that are set, which in this case is Dylan's Club Met. It's just a topic for future discussion if we should add anything to the bylaws or propose anything to add to the bylaws to ask for vetting of the whole membership list or not.
All right, thank you. I yield my time. Perfect timing.
Thank you, Mr. Gates. Would Mr. Frusiakis or Mr. Martin like to use any of their redirect time?
Yeah. I'll be sure to ask some further questions for Ryan.
Mr. Frusiakis, whenever you're ready.
So now, Ryan, in your opinion, wouldn't you agree that this particular last committee meeting that we had, it was a rather slow one because of how we had a lot of discussion and debates compared to a lot of our other meetings?
Yeah, I believe it took about close to 40 minutes.
Yeah. And would you say that's because we did a really thorough job of having to go through the Constitution, going through the bylaws to make sure that every objection that Leslie Garcia brought up was adequately addressed?
Yes, every objection she brought up was verified by looking through the bylaws during the call.
Yeah. And did we have a healthy discussion between all the members? And, did even Leslie admit at some points that she had been wrong towards the end of the committee to points that she brought up earlier in the committee?
Yes, that is correct. All members
minute 30 remaining.
stated their opinions on the matter.
Okay. Thank you. That exhausts my time.
Thank you, Mr. Frusiakis. At this time, Mr. Pavey, thank you so much for your compelling testimony. The Judicial Board thanks you. You are excused.
Right.
At this time, we'll be hearing from the next witness. Mr. Martin, who's your next witness?
The defense calls Jordan Jarvis as the next witness.
Miss Jordan. Salutation.
Hello.
At this time, it is my duty pursuant to section 2.1.6 to inform you of your obligation to tell the truth prior to presenting testimony before the Judicial Board. Therefore, I'll be administering this oath to you. Please repeat after me. I state your name.
I, Jordan Jarvis,
Do solemnly swear
that
I will tell the truth,
I will tell the truth,
the whole truth, and nothing but the truth.
and nothing but the truth.
So help me God.
So help me God.
Thank you. The defense may begin their direct examination.
Hi, Jordan. Can you tell me what your position is at Republicans at UCSD?
Yes, I am the VP of Internal Communications.
To your knowledge, were all chartering materials submitted legitimate and in accordance with CCR rules and procedures?
Yes, they were. We had our membership list all in order, as well as the Constitution and our recognition from UCSD, the Center of Student Involvement.
Awesome. Are Republicans at UCSD an official student organization registered with UCSD?
Yes, they are.
Does UCSD, to your knowledge, designate certain student organizations more official or real than others?
No. Every organization that goes through the process is then recognized and posted to the website, and they receive all of their information.
Okay. Why did you choose to join Republicans at UCSD as opposed to continuing with McNally's club?
Well, that organization, in my opinion, was something that had been on the decline for like at least the past year. Whenever I like first joined the organization, it was whenever Quentin Grounds and like Felipe were like still in charge. It was a really strong organization, tons of like healthy discussion, activism events and such. But whenever Jerry Shen took over, he was called our troll president for a while. It was kind of just like a joke that he was in charge, and so things just like weren't
Only
taken
30
seriously.
remaining.
And then whenever like Michaela and stuff was like voted in, I just felt like it was going to be a repeat of the same thing.
Mm-hmm. To your knowledge, did Jerry Shen or McNally's boards work actively with CCR and or make efforts to be active in San Diego or the state?
No, not in the slightest.
Can you describe your knowledge of the plans Republicans at UCSD currently has to promote activism and or work with CCR and the CRP?
Of course. So we're planning to start our meetings come the beginning of winter quarter. And with that, we've already arranged for Carl DeMaio, who is an ex-city council representative, to come in and speak. We've also been in contact with Sean Steele of the Republican National Committee, who's going to come in. In addition, we're in the planning stages of like large-scale events, like hosting Milo on campus. But in addition to like having speakers, we've also been in contact with the SDGOP chairman, who's going to be linking us with regional political coordinators so we can actually go out and do activism events.
Awesome. Yield time to redirect.
Thank you. At this time, Mr. Gates, you may cross-examine the witness.
Okay. Hi, Jordan. Thank you for coming. So you mentioned that the college Republicans at UC San Diego were on the decline for some while. Were you an active member of their club at the time of Dylan submitting the new credentials materials? And if so, how many meetings did you attend last year?
So I was considered an active member for fall quarter and winter quarter. Spring quarter is whenever I quit attending because that's when things started to get hazy. I was there whenever they did nominations for elections, but aside from that, no.
How many meetings did you attend in spring or fall and winter?
In fall, most of them. Winter quarter was probably around like 3 or 4 meetings, but 3 meetings is what's necessary to be considered an active member. I'm still on their active mailing list as well as their Facebook page. So I was still receiving all their information and still.
And do you believe that the
member.
executive board, if I recall an executive board member, that they'd be able to verify that you've attended that many meetings?
Yeah. For a while, Michaela was the secretary, so Michaela has record of my attendance.
Thank you. I also wanted to ask, what made you want to join the new org? Like, what did Dylan tell you?
Well, it was less of what Dylan told me and more of what I had been reading. There was a lot of things that kind of like started falling apart with the other org, with like the actual college Republicans at UCSD. Their meetings were kind of just like really hectic. They were getting into a lot of like Facebook feuds.
1 minute 30 remaining.
So I had just seen a lot of that going on, and that's kind of what caused me to quit attending meetings come spring quarter, because it just wasn't the organization I wanted to be part of.
Thank you. Another thing I have to ask is, taking a look at the membership list that was submitted to the Credentials Committee, I see that there were people that the college Republicans at UCSD have claimed are graduates, including Becca Ruiz. How did you obtain these names? Did you guys table? Did you have a meeting and Becca Ruiz and others came to that meeting?
Most our membership list was compiled by having like emailed members. So there
you
was no,
emailed
like,
Becca Ruiz and asked her if she wanted to be a part of the club?
I personally did not contact her.
Okay, thank you. Another question that I have is, regarding graduates, are you aware of any graduates on the membership list?
30 seconds remaining.
I have not reviewed the membership list as of lately, so I'm not qualified to answer your question.
Okay, awesome. Thank you. I yield the rest of my time.
Thank you, Mr. Gates. Was there any time left for redirect, Mr. Brum?
Yes, there was 30 seconds.
Do you wish to use your 30 seconds?
Yes.
Whenever you're ready.
Jordan, you mentioned that the conduct was going down the hill in the other club. Could you expand on maybe what some of that conduct was?
It was just a lot of like bickering and fighting, whether it was on Facebook or in their actual meetings. It was kind of just like yelling whenever they were doing like nominations for elections. It was just like incessant bickering. It just wasn't productive.
To your knowledge, was any of that conduct supported or
time has expired?
That's fine.
Thank you, Mr. Martin. Thank you so much, Ms. Jordan. Your testimony was compelling. At this time, the Judicial Board will now excuse you. Thank you so much.
Bye.
Yes.
Does the defense wish to call their next witness?
Yes, we will now call forth Christopher Casillas.
Mr. Casillas, are you on?
Yes, I'm here.
Mr. Casillas, pursuant to the rules of procedure of the Judicial Board 2.1.6, I am required to inform you of your obligation to tell the truth prior to presenting testimony before the Judicial Board. Therefore, I will be administering an oath. Please repeat after me. I state your name.
I, Christopher Casillas,
Do solemnly swear
do solemnly swear
that I will tell the truth,
that I will tell the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
So help me God.
So help me God.
Thank you very much, Mr. Casillas. The defense may commence with their direct examination.
Alrighty, I'll handle these questions for Chris. Alrighty, so Mr. Casillas, did we as the Credentials Committee debate the merit of Dylan Martin's membership?
Yes.
And do you feel that various perspectives were considered by the Credentials Committee when we debated the merit of Mr. Martin's materials?
Yes.
In your opinion, did Mr. Martin's club materials adequately meet the 4 criterion listed in the Credentials Code for a charter to be approved?
Yes.
Okay. Next question. Were you an active member of the Credentials Committee back in June of this year when the committee referred the UCSD matter to the Judicial Board?
Yes. I remember that meeting. I think I was the actual one that called for this whole thing to be sent to the Judicial Board. So yes, I remember it.
And did the Credentials Committee ever? So this one's actually very important. So let me state this one very clearly for everybody. Did the Credentials Committee ever officially restore the McNally chartering materials after rescinding the original Martin materials?
To my knowledge, no.
Okay. So therefore, is it accurate to say that the Credentials Committee canceled McNally's club charter when we originally approved Mr. Martin's materials back in June?
Yes.
And finally, is Mr. Martin's club the only officially recognized CCR club from UCSD as of now?
As of now, yes.
As of
1
now,
minute
yes.
30 remaining.
Very good. Thank you, Your Honor. I'm going to redirect the time for my questioning now.
Thank you very much, Mr. Frusiakis. At this time, Mr. Gates, would you like to cross-examine the witness?
Yes. Oh, do I just start? Hello?
Yes, whenever you're ready.
Okay, Mr. Casillas. So I remember Leslie mentioned in her testimony that there was a dissenting voice, or there was at least someone who thought that her objections were valid. Are you that person?
Thought her objections were valid. What do you mean?
Her objection to the membership list being copied.
She talked about it during the meeting. She didn't provide proof beforehand, during, or after. So I still haven't seen proof that it was actually fraudulent. During this time, she talked about it. Debate kind of heated a little bit, and then Pano also talked about it as well. So feeling that her stuff is valid, I mean, I only think things are valid if you're able to provide evidence, and she still hasn't provided evidence to Credentials Committee that this membership list is fraudulent. She didn't do so before, during, or after. So.
Okay. Another question I have, Mr. Casillas, is did Leslie offer to send this evidence?
She mentioned, she kept saying that, like, do you want me to send it? Do you want me to send it? But
And
she
you
never
said what?
did. She, when the debate kind of got a little heated, and she said that she kept asking, like, I have evidence, I have proof. Do you want me to send it? Do you want me to send it? But she
And
never
what did you
did.
say to that question?
I didn't say anything to that question at this time. She was mainly talking to Pano about it all.
Okay, so you did not say you wanted the evidence.
1 minute 30 remaining.
I didn't say anything at all, no.
Okay. Thank you. I yield it for Pano.
Thank you, Mr. Gates. Mr. Frisiakis, do you want to use any more of your time? Mr. Brum, how long does he have? Mr. Brum.
Sorry, he has 127 remaining. 1 minute 27 seconds.
Thank you. Mr. Frisiakis, whenever you're ready.
No, actually, that's going to be sufficient. That's going to be good.
Thank you, Mr. Frisiakis. So at this time, thank you so much, Mr. Casillas, for providing your testimony to the Judicial Board.
No problem. Thank you.
Good night. Does the defense wish to call any more witnesses?
Your Honor, can I request a short recess?
Yes. We can have a short recess and we will meet back at 9:20.
All right.
All right, it's 9:20. Mr. Gates in the defense, are you back?
Yes.
Matthew?
Oh, I'm back on.
Yeah, I'm still here.
Excellent. Mr. Brum?
Yes, I am here.
Excellent. We'll be calling this meeting to order at this time then. Does the defense wish to call their next witness?
Yes, the defense calls Panayotis Frusiakis. I'm sorry for butchering your name.
It's okay.
Mr. Frusiakis, we're going pursuant to Rule 2.1.6, all witnesses shall be informed of their obligation to tell the truth prior to presenting testimony before the judicial board. Therefore, I'm going to ask that you please repeat this oath after me. I state your name.
I, Panayotis Frusiakis,
Do solemnly swear
do solemnly swear
that I will tell the truth,
that I will tell the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
So help me God.
So help me God.
Thank you, Mr. Frusiakis. The defense may begin their direct examination.
Okay. What extent did you communicate with me about credentials materials being submitted?
We had an email, so I received an email from you, and it was like, here you go. So please approve this, and I hope that it meets the requirements and everything like that. And we overlooked it. We looked into it, and it does. So that's about it.
So would it be accurate to say there was no like nefarious scheming, or substantive communications over that?
There was absolutely no substantive communications over it. There was no conspiracy. There was none of that.
Okay. On June 3rd, 2018, when Drew Olbrandt, Sarah Garcia, and I requested a charter update with CCR, were Drew Olbrandt and or Sarah Garcia currently listed as executive board members on file?
Yes, they were. That's the bottom line is yes.
So did they have executive authority over chartering materials outlined in CCR bylaws, Article 3, Section 2B?
Absolutely.
Could they have proxied that duty of updating materials to someone else?
Yes, it's their right to do so.
Okay. Did I make you aware on November 27th that my chartering materials were for a new club?
Yeah. I mean, that was pretty clear, and it was also pretty, obvious as well, because it was like, a new name as well. So it wasn't a problem.
Okay.
Yeah.
Did you and or others
1 minute 30 seconds remaining.
What is it?
Seconds.
Did you and or others on the credentials committee verify the membership list I submitted on November 27th?
Yes, we looked into it and we discussed it very thoroughly. We had multiple members talk about it, and we were able to get it passed. So because we discussed it and it met all the criterion, so it got passed. So that's it.
Did you and or others on the credentials committee verify the letter of school recognition I submitted on November 27th?
Yes, we thoroughly looked at every single piece that was submitted to us.
So did you also verify the executive board roster and constitution that were submitted?
Yes.
So is it accurate to say that all materials submitted on November 27th match credentials code requirements at the time of submission?
Yes, it's absolutely fair to say that.
Okay. The defense redirects time.
Thank you. At this time, Mr. Gates, do you wish to cross-examine the witness?
Yeah. Yes.
Whenever you're ready.
Okay. Mr. Pano, so since no evidence that I submitted at the preliminary was dismissed officially, I am able to ask you this. What do you say to the screenshot in the evidence of you telling McNally that Dylan's chapter was illegitimate?
So I will tell you again, like I told you.
And why did you believe it back then?
I'll tell you again, like I said during the preliminary, and I will say again that I don't think that has any pertinence to this case at all. And I quite honestly think it should be objected to on relevancy, in my opinion.
So you don't think that it's pertinent to the case that the credentials chair, who is running on a slate with Mr. Dylan Martin, now suddenly thinks that it's legitimate?
So these are very loaded questions here.
Objection, relevancy. How is this relevant to
it's relevant because if you have a credentials chair saying that a chapter is illegitimate, and then after he's on a slate with the person in question says that it's legitimate, there's obviously some sort of change there. I want to know why there was a change. Why is what you told McNally different from what you told Mr. Martin?
So the defense can make that argument. I'm not going to sustain it because we should have made these objections in the preliminary trial, though.
Okay. So then I will answer that then. My answer to that is very simply that as was submitted, and the evidence, you can see it by looking at the preliminary minutes and all that. The evidence that was submitted by the plaintiff, by Andrew, is only a screenshot of the full conversation that I had with McNally. And during that time is I wanted, and times were different back then as well, and I wasn't the head of the credentials committee either, and things were different in terms of the details that were coming out. And how I discussed it with McNally is I was saying, I want everybody to remain in CCR. I want old charters, I want old schools to remain in CCR. So I was telling her, I want you to stay in CCR. And so I was willing to tell her anything necessary to make her stay in CCR. So it's very easy to make it seem like I flip-flopped, and maybe perhaps I did.
1 minute 30 seconds remaining.
But quite honestly, to be very honest and straightforward with you, it was all in the achieving the ends of trying to keep them to stay within CCR. And that's what I try to do. And quite honestly, it didn't work out that way in my opinion, because like she told me directly in that line of communication, she did plan to actually decharter. And, that's why Andrew isn't showing everybody everything, is because what she told me was she was saying, screw CCR, I'm leaving anyways. I don't care about any of these people. So I want our entire club to leave the organization. So, if you were to show the whole conversation, then it'd be a very
Okay,
different
Bono, I get it. One more question related to that.
Okay.
Well, actually, two more questions. The first question is, so you are fully confident if Michaela ever released the full context of that it would match what you're saying right now?
I believe that if the full context was released, it would change the entire situation of how people could perceive the messages.
Okay,
So
last question. Michaela was messaging you privately, but did the College Republicans Executive Board at UC San Diego ever submit a formal letter of dechartering to the Credentials Committee via email, mail, or whatever? Or public statement, press release, anything?
I remember seeing stuff on Facebook, like press releases and stuff like
You saw a
that.
press release?
But I remember seeing press releases. However, I wasn't like the head of the committee at the time, so Chacon probably would have gotten more direct info on that.
Okay, hey, Kimo, I would like to recall a witness to confirm or deny that there was a press release released on behalf of
which
the UCSD
witness
College
are you
Republicans.
recalling, Mr. Gates?
McNally.
All right. That'll be taken into consideration. I'll actually heed that since it's relevant to the conversation, but we're going to finish the defense's witnesses first.
It's really not relevant, but okay.
It's not relevant that they didn't formally...
Gentlemen, out of order, please remain in decorum. At this time, does the defense have any more statements? Because the time has expired on redirect.
No further questions.
Excellent. I thank the defense. At this time, Mr. Frusiaki is a defendant, so he'll be obviously allowed to stay in the chat, but we thank Mr. Frusiaki for his time. Does the defense have any further witnesses?
Oh, yes, in fact, we do have. We're going to call forward Dylan Martin.
Excellent. Mr. Martin, I am required to inform you that you are required, pursuant to 2.1.6, to tell the truth to the Judicial Board. For that reason, I'm going to ask that you repeat this oath after I state it to you. I state your name.
I, Dylan Martin.
Do solemnly swear.
Do solemnly swear.
That I will tell the truth.
That I will tell the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
So help me God.
So help me God.
Thank you, Mr. Martin. At this time, the defense may commence their direct examination.
All right, Mr. Martin. So what is your response to the plaintiff's allegation against you that you are not a general club member in good standing?
This one is, it just was completely not true. I attended meetings starting a couple of years ago, right after Quentin Grounds was in the executive board and Felipe became president, and I was with them pretty much all throughout that year, at least a good 2 quarters of it. I was there for Jerry Shen's election, and through then, I was there into the first quarter of Jerry's presidency. And then the club really started to dissolve, and just, people were making Nazi jokes. They were terrible. But so I stopped going for a little while, but I came back in spring quarter for when elections were, and I went to pretty much every meeting leading up to elections so I could be in good standing. So I was a member in good standing, and they should have record of that. I don't know whether they would actually provide evidence of it, but I was there.
Okay. And does the UCSD administration officially recognize your club?
Yes, we are officially recognized at UCSD.
Perfect. And how would you respond to the argument that the college Republicans at UCSD, so McNally's club, is, quote, the official CR club on campus?
UCSD does not differentiate between levels of officialness on campus. So, I mean, we could also argue that we're the official club on campus. It really holds no weight because UCSD itself does not differentiate.
1 minute, 30 seconds remaining.
Did Drew Olbrandt's proxy charter update duties to you on June 3rd?
Yes. So when we were chartering for that first time, I mean, you know, it's relevant with the new club, but back then, Drew did give that duty to me. He was at work, I believe, and couldn't make it to a computer, and he asked me if I could submit things on his behalf. So he was fully aware that that was happening, and so was Sarah Garcia. And, you know, pursuant to the fact that they had executive authority, they directed that duty to me.
All right. Well, thank you very much, Your Honor. That is going to, we will now redirect our time for questions.
Mr. Brum, how much time do they have left?
52 seconds.
All right. Mr. Gates, you may begin your cross-examination.
All right, Dylan, yes or no, were you elected to the college Republicans at UC San Diego's executive board?
No.
Okay. Another question is, was the letter of school recognition that you submitted at the initial time of your chartership in summer, the letter of school recognition given to Republicans at UCSD or college Republicans at UCSD?
That letter was for college Republicans at UCSD, but we now have a letter that is for Republicans at UCSD.
But when you first chartered and for the 5 months leading up to your recent updated materials, you did not have a valid letter of school recognition.
It was a valid letter of recognition for the other club.
Okay, so you used the valid recognition for the other club for your own club. Thank you. My other question is, in the evidence, which you guys did not object to, so I can still refer to it, there is a screenshot of you telling your executive board, and this was released by the executive board members who defected from your club after realizing the full context, that you had lost the battle because, not fully, but partially lost the battle because the school administration did not recognize your club. Is that correct? They just decided McAnally was the rightful president. They had decided that they never dechartered, and they had decided that their executive board was legitimate, and you needed to, like, you couldn't use their club name. Is that correct?
Your Honor, I'm not exactly sure how to respond to the question because it contains a lot of presuppositions, but I can expand on it or try my best to.
Sure, go ahead.
Feel free to respond as you wish.
1 minute, 30 seconds remaining.
So after McNally versus Olbrandt's dismissed, McNally et al., they brought up a case with the Office of Student Conduct, and their charges were that that we had misused university documents, which was the letter of school recognition. We met with Benjamin White, which there is evidence in there that shows, and he was the director of student conduct. Very nice man, and he met with all of us and asked us our full stories and everything. And he was very concerned about wanting to do what was right and everything. And we did have, him, talk with each of us, and he felt like the other club had not dechartered. And so he allowed them to use the name College Republicans at UCSD. However, he did say that even though that was his decision, we were more than welcome to register under a different name. And he wouldn't
Okay,
object to
awesome.
us.
30 seconds remaining.
I have one more question, Dylan. So can I just, I understand what you're trying to say. My last question refers to what you just said, which is that they told you you can operate under a different name. My question is, have you ever sent an email trying to recruit members from the other club under the name College Republicans at UCSD?
So I know exactly what you're talking about, and that was actually, so, my email name for, it was the same email I had used at the beginning of the process, and at the time
has expired.
Your Honor, I'd like to finish answering the question.
You can finish answering.
So at the time, back in June, I had created the account under the name College Republicans at UCSD because that was what we were operating under. And recently I have changed the name to Republicans at UCSD. It was just a mistake on my part because we just formed this club really recently, and I have since changed the name. Actually, I credit Andrew because I think I was first made aware of that when you mentioned it. It was honestly a mistake on my part. I didn't know that it was still under that name for that account. But when I did sign off on emails at the signature line, I would say Republicans at UCSD.
Thank you. I yield my time for questions. I mean, the time's expired, but you get it.
Does the defense wish to redirect?
Yes. So Dylan, could you please elaborate on how relations with your club and the administration have changed as of recently, specifically in regards to the Office of Student Conduct and how they now essentially recognize, the full legitimacy of your club, and they recognize that, other than the name dispute, they recognize that your club is a very legitimate and valid club.
So Ben White and I are in communication occasionally, and I've talked to him about this process, trying to make sure that we have individual clubs, we're all proper and everything. He's pretty supportive. He wants us to, each be able to meet our own goals. He was the one that encouraged me to actually make the new club under the new name. And he really wants us to all be able to meet together, the other people, Michaela and everyone, and be able to sort it out. And so we don't hate each other. I mean, I'm open to it, but any communication I've had with the other side is basically pound sand. But
thank you, Mr. Martin. At this time, obviously, Mr. Martin is a defendant in the case, so you can say in the chat. But the Judicial Board would like to thank you for your compelling testimony. There doesn't seem to be. Is there any more witnesses the defense might have? Seeing none, and you hadn't submitted any others, so. At this time, Mr. Gates had a motion on the floor. In consulting with my fellow Associate Justice, Mr. Vitale, we decided to entertain your motion to recall the witness McNally. So, Mr. Gates, you may recall the witness, Miss McNally.
And okay, all right, one moment. I'm recalling her right now.
So, for the clerk to mark on this, Mr. Vitale and I decided to institute a special rule pursuant to the parliamentary rules to allow us to recall Ms. McNally.
Will this recall will be the standard 3 minutes with cross-examination and redirect, or will it just be Gates questioning McNally?
It'll be, I'm going to give them the same time period. It's a special rule, so I'll extend it if necessary. Mr. Vitale and I already decided to be flexible with this specific recall, but 3 minutes is what it stands at.
That's fine. Hey, Chemo, I had one more question just while she's joining and getting situated.
Yes.
In the interest of transparency, would you mind sending me a copy of this video downloaded, or at the very least, keep it uploaded to the YouTube channel after the trial?
Yeah, I keep it uploaded for a while. Usually we eventually take them down, but I'll have it up probably for a couple days.
Thank you. Let me know when you're ready for the witness.
Yes, we are ready for the witness, Miss McNally. Welcome back. You've already been sworn in, so the plaintiff may begin whenever they're ready.
Okay, Michaela, so I want you to expand a little bit briefly on Dylan's activity in the club leading up to your election.
Yeah, so when Jerry was the president, Dylan was not an active member. I have the attendance sheets because I was the secretary. Yeah, he definitely popped into maybe 1 or 2 meetings throughout the whole year, but he was not an active member. And while I'm on it, neither was Jordan.
So Jordan did not, and I quote, attend, sorry, I don't quote, but I paraphrase, attend a majority of the fall quarter meetings and 3 of the spring quarter meetings, or winter.
Your Honor, Chemo, can I object? You said that if the witness says something that is completely false, that we're allowed to move to impeach the witness?
You can move to impeach the witness if you wish.
How would that specifically work?
Say, I move to impeach the witness, state your reason.
I moved to impeach the witness on grounds that I was at the actual elections in the spring, and to participate in the elections, of which I did, you have to be a member in good standing. So Michaela just tried to state that I was not in good standing.
I thought he asked me about fall and winter. We have our elections in the spring. So if you voted in the spring, you were an active member in the spring, but he just asked me about fall and winter.
If the witness can correct themselves, otherwise we'll hear a response from the plaintiff.
Well, I'm not correcting myself. I'm saying that he's wrong. I'm saying that he could have been an active member in the spring where the election happened, and he could have voted for what seems like for Jerry.
I understand. We're only dealing with an issue of intent right now. So the question at hand is, to make this clear, was Dylan a member in good standing during spring quarter?
For my election or for Jerry's? Because we're talking about, we've crossed 2 years now in this case.
Perfect. So let's just go for both.
Dylan voted for Jerry, but Dylan did not vote in my election, which is obviously the more recent one. Neither did Jordan.
If that's the case, then yes, I moved to impeach the witness because I did vote in that election.
Okay.
All right. We'll give you a moment to pull the rule.
Okay, well, can I at least pull up my attendance then?
Yes, Ms. McNally, if you would pull up your attendance sheet, pursuant to the parliamentary rules, they should be in minutes.
So is he talking about Jerry's or mine?
Yours.
So to clarify, you believe, or you state in full truth, that that during your election, Dylan was not a good member in standing and did not vote. Dylan contrasts that and states he did vote.
Yes, I understand. I'm going to pull up my attendance. Okay. So Dylan voted and Jordan didn't. So there's my mistake. Since Jordan said that she was at the meetings, I was just confusing the fact that one of them that said they were there wasn't, and the other was.
For future references, let's just prescribe ourselves specifically to the documents at hand.
Okay,
I would highly recommend.
Thank you.
If the witness would allow me, I would highly recommend you simply state, I don't recall, if it comes up to something like that, because Rule 609 is very specific in attacking the credibility of somebody in reference to this. And of course, Rule 407 is very specific on the measures of negligence that are necessary to prove impeachment.
Well, luckily I just got to pull up my attendance, so there you are.
So please in the future just state, I don't recall. Mr. Brum, did you pause the time?
Yes, I did.
Thank you, Mr. Brum. Will Mr. Gates please commence? Mr. Gates. I believe your mic is off, Mr. Gates.
Okay. All right. Sorry, I lost my paper. Would you mind if I just look through my notes?
The time's paused.
Nope. I'll give you a minute to get back to where you were, Mr. Gates.
I found it.
Begin when ready.
So, Michaela, was the Constitution that Dylan submitted to the credentialing materials, to the best of your knowledge, was that the Constitution that your current club has?
Yeah, same exact Constitution.
And I'm sure you're aware of the membership list submitted to the Credentials Committee recently, and the first time it was submitted. Can you expand? I know that there were mentions of some of the members like Becca Rees and others being graduates or not being involved.
Yeah. So since that membership list was from when Jerry was president, Jerry's credentials and chartered those. So there are no longer valid because they have a bunch of people that graduated because those are from
1 minute 30 seconds
go
remaining.
now. So those are no longer even our membership lists that they still continue to use because we don't use people that are graduated and not actual members.
Okay. And another thing I want to know is, what is your story of, I think his name was Ben White, right? Or Brian White or something like that?
Ben White, yeah.
Ben White, did he ever, what was his ruling on the initial dispute?
Yeah, so after I went to student conduct with Ben White, he sent me a follow-up email, which is in the evidence, pretty much just stating that we did not make any attempt to contact CCR about dechartering. We didn't put out any press release. And ultimately, he just stated that he found that we did not decharter.
And he also found that you were the only legitimate president, right? Not Drew?
Yeah, Drew didn't even run for an e-board position. He was not on the e-board. And since they said that we did not decharter and they said I was the College Republicans president, that's why you hear Dylan talking about this new club that he made. It's because he had to make it, and he was able to charter it only because he dechartered us for us. So that's the only reason why he's able to pull together 5 random students to make a new club, as anyone can on a college campus. But we are the College Republicans, and Ben White, student of conduct.
Time has expired.
We didn't charter.
Awesome, thank you.
Yep.
Would the defense like to cross-examine the witness?
No questions, Your Honor.
Very well. The Judicial Board has a few questions while we have you back, Ms. McNally. Could you describe the separation of the clubs? Meaning in practical terms. I believe your mic is off.
Sorry, thank you. I did mute it. Well, what confuses me about this question is because there was no separation of clubs when this first started back after my election and my e-board's election, because Dylan's club obviously did not exist until maybe a month ago, 2 months ago. So there was no separation of clubs because there was only the College Republicans at UCSD.
Right. So perhaps the question is, how do you think the separation has changed over the time frame between the prior case and this case?
So now, like I said, just as anyone can on a college campus, Dylan found 4 other people to put their name down as principal members, and he made a club named Republicans at UCSD. So the problem with this is he's claiming to be chartered, but our College Republicans at UCSD never dechartered. So ultimately, he's only chartered on the fact that he dechartered our club for us back at the beginning by issuing a press release on our behalf saying that he was now the vice president and Drew was the president. And Drew is no longer even involved in CRs. He resigned from your position, CCR leadership, and he's no longer even on the principal member list of Dylan's new club. So ultimately, the only reason why Dylan's club exists is because he dechartered our club for us and now is claiming to be chartered.
So what do you mean the only reason he exists is because he dechartered? Do you mean like his club is claiming he's still your club, or are they 2 separate entities? Like, you guys don't claim the same rooms physically, right?
Right. I wanna make this clear. At the beginning, when he submitted our chartering materials, he had no club and he was not the Republicans at UCSD. So I think you guys are blurring the lines between how now, at the beginning of this year, he made a club. But at the time when he submitted our charting materials and our email to Jerry Shen, and he claimed to be the College Republicans at UCSD, those were 2 separate times. And now he's saying, oh, it's okay, I have a club. But that's months after he already used our name and emailed people using our name, sent out a press release using our name. So they're 2 different time frames, and you guys are trying to blur them like that they're one time frame. But now, yes, he has a club, just as anyone can on a college campus get together 5 of their friends to make a club. But at the time, he was not a club, and he was just using the College Republicans name, which was not his because we never dechartered. Does that make sense?
Yes, I understand that perspective. Thank you. At this time, it seems as we've expired time. The Judicial Board would like to thank Ms. McNally for her compelling testimony, and we will excuse you at this time.
Thanks.
Thank you.
At this time, it seems as we've gone through all the witnesses. Are there any final motions on the floor? Seeing none, we're going to move into our final comment section. The plaintiff is going to have 5 minutes to make your closing statement, and that's pursuant to 2.5.1. Mr. Gates, whenever you're ready.
I'm sorry, you said that this is my closing statement?
Yes. Obviously, we're going to have oral arguments after this, but closing statement for the trial.
All right. Well, I would just like to remind the Judicial Board once again that you have a moral and professional duty to uphold the legitimate California College Republicans chapter at UC San Diego. I think that if there's any shred of decency left, you will charter McNally's Club once again. I think that it's clear Dylan doesn't know what he's talking about because he literally faltered during my line of questioning and admitted that he submitted a letter of school recognition that was not his. So he did admit to stealing credentials materials. And since he swore in at the beginning of this trial and at the preliminary trial when the charges were read against him, I think that he needs to be held accountable for that because he explicitly denied my claim that he stole or used illegitimate materials. I think that finally, you did mention that you are going to leave this up for a few days. I really appreciate that. I hope you actually do, because I know the Madison and Sarah Morcott trial was deleted a few hours after, maybe a couple hours. And I really think that in the interest of transparency, we need to download this and have people be able to review it. Because I think if anyone sees this with a rational mind, with a non-slate focused mind, with a non-slimy back and forth flip-floppy mind, like some people on Champion, then I think that they will know who the legitimate chapter is. It's not the chapter with 2 people. I'm sorry. It's the chapter with 30 people, a healthy historic board, a healthy membership. And yeah, that's it. I end my time.
Thank you, Mr. Gates. Will the defense like to make their 5-minute closing statement?
Yes, we would. All right. Your Honors, as was said in our opening statement, this case boils down to questions of fact and law, as opposed to the political and emotional rhetoric of the plaintiffs. The plaintiff's prayer for relief, quote, the plaintiff requests that Dylan Martin's illegally granted chapter credentials be revoked and that the materials submitted by the duly elected executive board be upheld and recognized again, end quote. Simply, procedurally is irrelevant now at the chartering of an entirely new club, Republicans at UCSD, as we brought up before. Chapter credentials, as we have proven, are entirely legal and legitimate for Republicans at UCSD. They cannot be revoked merely because the plaintiff doesn't like the new club or they wish to be chartered again. As outlined in the case of McNally v. Olbrantz, we, the defense, are entitled to our due process rights and are protected against the frivolous demands, wants, and whims of the plaintiffs. We feel for the frustration of the plaintiffs, but on question of fact and law, their charges hold no merit. With every charge listed, the charge can and has easily been refuted by the evidence that we have provided. Again, as is so pertinent, we raise a key issue in the opinion on McNally v. Olbrantz. The ends, it seems, does, in fact, if McNally, who's a representative of the plaintiff, if she wished to pursue a future case, she was caught in a double legal bind. And this is a quote from the case itself. Let me make that clear. So either she admits her prior case held merit and was dismissed without good cause, or she believes her case had no merit, at which point the defense would immediately claim innocence, end quote. So we ask your honors that you heavily weigh this. Why bring these charges that hold no merit now, only after a new club has been chartered, which renders their standing on a large basis of their argument null and irrelevant, except a cause of spectacle for political aims? Representative Gates, as a matter of public record, has derided the Judicial Board as a sham and as a kangaroo court as he said, even in the past few hours. He's even been on the record, saying, and McNally is as well, I should say McNally specifically has been on the record saying that why should she show up to, quote, your mock trial conference, which wouldn't do anything but give legitimacy to your farcical judicial board by rejecting entirely the authority of your sorry excuse for a judiciary. We are standing up against your regime of imperious oppression and reckless arrogance. We would accept no ruling, whether against or in our favor, from a body that serves to ensure an illegitimate leadership from consequences. So those are the words of McNally. So here's this. McNally v. Olbrantz was dismissed without good cause, reflecting incompetence and or negligence on the part of the plaintiff. And this case represents a bumbling attempt to repair the plaintiff's image and standing, or the plaintiffs dismissed the previous case because they knew it had no merits. They knew that it wasn't a good case, and they're just bringing it up again because they want to turn this into a political circus against CCR. They want to damage our reputations. This is why Representative Gates wants this video to be out there, is because he has made it a political circus to destroy the legitimacy in their eyes of this organization. But again, it is our duty to study and account for facts. And the fact is that the plaintiff's charges hold no legal merit. And Republicans at UCSD is a legitimate force on campus at UCSD, formed and chartered under all legal rules and procedures, both at UCSD and within CCR. Within the Credentials Committee, it passed all the criterion listed in the Constitution. We were extremely specific to the Constitution, and we upheld everyone's arguments. We listened to some of the witnesses that have been brought up by the plaintiff tonight brought up those arguments during our Credentials Committee meetings. They were discussed and they were entertained. There was no collusion. There was no evil conspiracy going on. And given that, and given all this information, the defense would like to rest our case. Thank you very much, Your Honors.
Thank you, Mr. Cruciakis. At this time, board members will be allowed to ask questions to either party. There are no other witnesses present, so we don't need to ask them questions. So, Mr. Gates, I only had one question for you. You said in your closing statement you wanted the one of the defendants, Mr. Dylan Martin, to be held personally responsible. Is there an argument on the difference of relief, or is it still just the chartering?
I'm not sure what you mean by that. Are you saying, am I addressing the original thing or their petition to
No. I'm asking if your relief is asking for more than just.
Oh no, my relief remains the same. I was more making a moral argument.
Okay.
Than formally charging him of being like immoral, which I don't think the judicial board should investigate.
Yes, of course. All right, those are my only questions. Matt, do you have any final questions?
No, I've seen what I had to see.
Thank you, Mr. Vitale. At this time, then, according to Rule 3, 2.5.4, we will be going into closed deliberation. However, the special rules have it that we'll now be hearing oral arguments, pull that up, pursuant to the motion to dismiss. So this is the outside of the direct trial. It's just the immediate motion to dismiss based on grounds. On this,
can you explain how should we report on that oral?
Sorry, Mr. Brum.
How should this reflect on the minutes? Should this be a new proceeding, or should this be at the bottom of the trial proceedings?
At the bottom of the trial proceedings, put special ruling for oral argument on the motion to dismiss by the defense.
All right.
Mr. Gandalf, for the oral arguments, could you re-explain? I think you outlined some things that we needed to meet at the beginning before this, but could you re-explain?
I sent Olva to you prior. It's going to be similar to before, but here's how it goes. The plaintiff, and this should be in everyone's email. I need to send it to Kevin, I believe, still, but it should be in both your emails. But this is the general outline. The plaintiff will have 10-minute opening speech, The plaintiff can be cross-examined by the defense for 5 minutes. The defense will have 10-minute opening. Then the defense can be cross-examined by the plaintiff for, it should be 5 minutes. That's incorrect. For 5 minutes. Then the plaintiff will have a 5-minute rebuttal. The defense will have a 5-minute rebuttal, and then final questions by justices.
Wait, just one more time. What is the time for each opening? Is it 10,
10.
then 5, 5, 5?
It's 10. Yeah. So 10-minute opening plaintiff, 5-minute cross-exam, 10-minute opening defense, 5-minute cross-exam, and then 5-minute rebuttals before final questions.
All right.
Gentlemen, at this time, we'll be opening the special rules for oral argument on the motion to dismiss by the plaintiff as viewed by page 3 of notice 3 that I had sent out to all parties. Please note that there is a scrivener's error on page 3 that says the defense's cross-examination is 10 minutes. It should be 5 minutes. Moving forward, we'll now be hearing from the plaintiff for 10 minutes. Mr. Gates?
Yeah, so I don't understand why I'm going first. It seems since it's his motion he's proposing, would you mind if we just arranged it such that he can present his argument and then I can more aptly respond to it?
I'm fine listening to that motion. Mr. Vitale? Any objections?
No, I think that is a reasonable way to do it.
Excellent. Thank you, Mr. Gates, for making that motion. That'll be taken into consideration and is accepted by the Judicial Board. We'll switch that around. So the defense will be having their opening. The ones making the motion have the burden of proof first. Mr. Martin or Mr. Frusiakis, you have 10 minutes.
Okay. So according to the CCR Constitution in Article 10, Section 1, a charter is awarded to a club when they meet certain qualifications. As referenced in McNally versus Olbrantz, there are 4 prongs to a properly submitted chapter. Namely, the Constitution requires credentials materials to be accredited by a minimum of the following. And this is a quote, membership list with each member's name, phone number and email address. B, a list of officers with names, positions, phone numbers, email addresses, and mailing addresses. C, a letter of school recognition. And D, a copy of the club's constitution, according to CCR Constitution, Article 10, Section 1. End quote. Credentials/charters are granted to clubs after certification of the required elements by the Credentials Committee pursuant to the authority under California College Republican bylaws, Article 3, Section 1, Article 7, Section 1, and Credentials Codes, Section 1 and 5. On November 27th, 2018, I received confirmation from the University of California, San Diego, that our club, Republicans at UCSD, is appropriately registered and accredited with the university. And on that same day, I submitted the required paperwork and materials for credentialing to the California College Republicans Credentials Committee, pursuant to CCR Constitution, Article 3, Section 4 and 5, CCR Bylaws, Article 3, Section 1, and Article 7, Section 1, and Credentials Code, Section 5. On December 6th, 2018, the CCR Credentials Committee approved that charter and by extension the new club for UCSD pursuant to their authority derived from Credentials Code Section 1. UCSD's charter was amended to reflect the new club, and the defendants, myself, we assumed those offices assigned to us on the charter. So the plaintiffs at that point then sued, arguing that our new charter is illegitimate, an illegitimate usurpation of their credentials. However, prior to this suit, the plaintiffs were not credentialed, and additionally, during the 6 months following the dismissal of the, my camera did something weird. Sorry. Additionally, during the 6 months following the dismissal of the last case related to UCSD credentials, McNally versus Olbrantz, in which the plaintiffs voluntarily dismissed their own case and thus their claim to credentials, the plaintiffs made no move to attempt to credential themselves within that 6 months. Only after the approval of a new charter for a new club have the plaintiffs stepped forward to claim they should be credentialed. The Credentials Committee, according to Credentials Code Section 1, holds authority over approving charters and thus legitimacy of any club petitioning CCR for credentials. The Credentials Committee approved the charter of Republicans at UCSD by majority vote, which you can see in the minutes. The plaintiffs' claims can be dismissed because they're without merit. The process to amend the charter was legitimate and legal. It was in accordance with the CCR Constitution and Credentials Code. According to the CCR Constitution, Article 3, Section 2, as long as there is one club in good standing on any given campus, no other Republican club may become a CCR club in good standing on that campus, end quote. Therefore, the case the plaintiffs have brought forward in an effort to credential themselves / correct their credential with CCR is obsolete and irrelevant, as the Credentials Committee has already awarded credentials to one club at UCSD, Republicans at UCSD. Plaintiffs have no standing to challenge the charter of Republicans at UCSD on grounds of legitimacy. Additionally, the plaintiff's pursuance of action on UCSD credentials presents the dilemma outlined in the opinion of McNally versus Olbrantz. Quote, the ends it does seem is that if McNally, a representative of the plaintiff, wishes to pursue a future case, she is caught in a legal double bind. Either she admits her prior case held merit and was dismissed without good cause, or she believes her case had merit or had no merit, and at which point the defense would immediately claim innocence. Taking this into account, we find the plaintiffs have no understanding or respect for the chartering process, and we believe the current action by the plaintiffs constitutes a nuisance. According to common law principles and stated in cross-text Northern Pipeline LP versus Gardner, quote, taking this opportunity to clarify the law, we hold that the term nuisance refers not to a defendant's conduct or a legal claim or cause of action, but to a type of legal injury involving interference with the use and enjoyment of real property. We further clarify that a defendant can be liable for causing a nuisance if the defendant intentionally causes it, negligently causes it, or in limited circumstances causes it by engaging in abnormally dangerous or ultra-hazardous activities. The petition that sparked McNally versus Olbrantz, the case's subsequent dismissal by the plaintiffs without reason, and the current petition brought forth only after a new club has been chartered, after a 6-month period of time in which no action was taken by the plaintiffs, to be a continued annoyance and interference with the use and enjoyment of our property, the Republicans at UCSD. We ask your honors that you heavily weigh this. Why bring these charges that hold no merit now, only after a new club has been chartered, which renders their standing on
5 minutes remaining.
Their argument null and irrelevant, except to cause a spectacle for political aims? McNally herself, in her dismissal notice for McNally versus Olbrantz, a matter of public record, said, showing up to your mock trial conference would do nothing but give legitimacy to your farcical judicial board. By rejecting entirely the authority of your sorry excuse for a judiciary, we are standing up against a regime of imperious oppression and reckless arrogance. We would accept no ruling, whether against or in our favor, from a body that serves to ensure an illegitimate leadership from consequences, end quote. So here's this. McNally versus Olbrantz was dismissed without good cause, reflecting incompetence and or negligence on the part of the plaintiff, and this case represents a bumbling attempt to repair the plaintiff's image and standing. Or the plaintiffs dismissed the previous case because they knew it had no merits, just as this case, and they are bringing it up again for political reasons, to make a mockery of the defense and this court, and to attempt to damage reputations. Therefore, we, the defendants, Dylan Martin and Panagiotis Frusiakis, in this matter of UCSD College Republicans versus Martin, etc., respectfully move the judicial board to dismiss on grounds with prejudice to provide relief for the annoyance of continued claims against properly filed credentials and immediately reject the plaintiff's case. The defense rests this portion.
Thank you. At this time, Mr. Gate, you will
how
have.
much time did we have left?
Oh, would you like to continue?
Yes.
Yeah, I just want to give a very quick summary, essentially, of what was just said. I kind of wanted to say that the bottom line. I'm sorry, what?
Just a moment. All right, go.
Okay. I just wanted to essentially give like a really quick summary. The bottom line is, and this is a pretty slam dunk reason why this motion should be accepted, is because McNally never reinstated her charter. So back in June 6th, the bottom line is once that charter officially was rescinded upon the approval of Dylan's original materials that were later rescinded on June 11th, despite how that all went down, the second that on June 6th that the original Dylan Martin materials were approved, McNally's club no longer was chartered with CCR. And I'm interested to see what the argument against that's going to be, because in my opinion, that's a pretty like 1 + 1 = 2. Like the second that happened, it was really over for McNally. Like her club has not been associated with CCR since June 6th of this year. So everything that happened afterwards is we in the old committee rescinded the previous charter, but then UCSD has been in limbo that whole time. And that's because only one chapter can be chartered at any school at any time in credentials. So the UCSD has had no school there until very recently in our last meeting on December, just about a week or two ago, when we had the meeting. And then when we had that meeting, that's officially when Dylan's new club, the Republicans at UCSD, have been approved, and when the school now has that club as the officially chartered club. So that's the bottom line, is McNally has really had no standing or grounds on any of this since June 6th. So I wish we could have gone through this in the beginning. Unfortunately, that's not how the procedure is. But quite honestly, I think it's a pretty slam dunk decision. Is McNally really has no club and hasn't had one since June 6th of this year because of that reason. So thank you.
Thank you, Mr. Frutsiakis. At this time, Mr. Gates, you may cross-examine either of the defendants.
All right, Dylan. So you mentioned how the Constitution stipulates that if there is a chartered chapter on a campus, then no other chartered chapter can be no other chapter can be granted a charter. Is that correct? Your mic is muted.
Yes, your mic's muted. Sorry about that. There is a one club per campus constitutional rule for CCR. Yes.
Was there one club on the campus of UC San Diego at the time that you submitted credentialing materials to Pano? Not to Pano, my bad, to the credentials. I know that he wasn't there.
Because of the way it procedurally works out at all times, wait, I don't want to say something wrong. As far as I know, or I mean, like there has been only one club chartered at a time at any one time. Does that answer?
Right. Yeah, I understand that. I understand that there has only been one club chartered at any given time. What I'm asking is, in your argument for why this case should be dismissed, you mentioned that since there is an existing chartered chapter at UCSD, then no other people have a claim to starting their own chapter. Could that logic not also be used against you? Because at the time of you submitting your credentials materials, there was already an established legitimate chapter, and there can only be one chapter at a time. The materials you submitted specified a chapter and a process in that chapter by which people were elected, and you were not elected by that process. So your chapter was an entirely new chapter, as you said multiple times in this trial. You've said multiple times that they were not the same club, that you were establishing a new club. Is that correct?
I don't want to, stop me if I'm answering you wrong. So I'm a little lost. Okay, so our club, I believe I gave it in opening statements for the trial. So our club, we were able to register as far as I know, there isn't any specific requirement that prevents one club from registering over the other, besides that you can petition. But because I was on the previous charter materials prior to December 6th, and because I'm the president of this new club, in a way, I kind of gave myself authority, or just by not doing anything on behalf of the previous club or whatever that I was technically on charter material members for. With this new one, now I am the president officially, on this.
2 minutes, 30 seconds remaining.
That is coming in. I don't know if I'm.
And who was the president officially at the time of your submission of credentialing materials?
On which date?
The date that you initially submitted credentialing materials for your new club.
For the new club, the previous chapter or the previous president on record as of December 6th was Drew Olbrantz.
No. I'm saying your new club as of the time, during June 6th, when your credentials materials were approved. Before those were approved, who was the president of UCSD-CRs?
Prior to that, the one on record was Jerry Shen.
Okay. That's all I wanted to know for that question.
Further questions, Mr. Gates?
Yeah, so you mentioned how the credentials committee never rescinded the original charter given to your new club, to quote you. And you mentioned how Michaela McNally never submitted conflicting credentials material after you submitted yours. I'd like you to confirm that for me? Is that what actually happened? Because I'm looking
could
at
you expand
screenshots
on
right
that?
now of emails sent to the Credentials Committee saying that UCSD CRs under Michaela McNally, who was the president-elect, actually did submit credentials materials.
I'm confused by the line of questioning. I'm sorry.
I don't get.
wanna answer your
Let me
question.
clarify. All right. So let me pull up the email real quick. My bad. All right. So on
30 seconds remaining.
So on June 11th, 2018, an email was sent from Michaela McNally with the subject UCSD CR credentials of Real Club, Real in caps, to credentials at California GOP, collegegop.com, saying, and with the credentials materials. Do you deny that?
No, I don't think so. At the time, that was the central part
Time
of
has expired.
McNally v. Olbrandt's case, was the conflicting credentials materials submitted.
Okay. That's all for my questioning.
Thank you, Mr. Gates. At this time, Mr. Gates, you have 10 minutes opening for your argument. But before we start that, do you mind, we've just been on here a long time, if we take a quick 5-minute break? Would that be okay?
Please.
All right, we will meet back at 10:20.
Okay.
The Judicial Board's in recess. All right, is everybody back?
Yes.
All right, Mr. Brum.
Yes.
Perfect. All right, at this time, I'm calling the judicial board back to order. The plaintiffs may make their opening argument. Andrew, your mic is muting you.
Oh, my bad. Give me a second. Yeah, so I'd just like to start my opening statement by reiterating something Dylan actually said. And what Dylan said was that the Constitution stipulates if there is an existing chartered club on a campus, there cannot be a second one. However, and when the video is made public and downloaded, I hope you review this, Dylan has explicitly stated multiple times throughout the entire video that his club was a different entity. It was a different club. It was a new club under a different name. Although originally it was not under a different name, but let's go by that. If that's the case, then Dylan's entire argument applies to his club at the original granting of his chartership. Because there was already a club under the leadership of, technically, Jerry Shen was president still, and Michaela McNally was the president-elect, then Dylan wasn't able to submit a club chartership request at all. Another thing that I will say is that multiple times, Panayiotis has said in his statement that Michaela never submitted additional credentialing materials after Dylan tried to claim that his chapter was the valid one, which is explicitly false. As I said in my line of questioning towards Dylan, she did submit new materials, and she did affirm that she was indeed the president. Another thing I want to address is that Pano and Dylan, I believe Dylan, if I'm wrong, then I'm wrong, but I know that Pano has referred to McNally just being like angrily dismissive and hating the judicial board and all this stuff. I want to point out that since the judicial board wants to, like, you know, emulate real life courts, if you're charged with a crime and somebody brings up the fact that in the past you said, like, I don't respect the judicial system, or the judicial system like doesn't represent me, they hate me, right? If somebody thinks that they're like not represented by the system in power or the government, that's not an argument against their claim. That's not an argument to be used to dismiss their claim or to say that for all future cases that they're involved in their entire life, they can't like their claims would just be dismissed because they insulted the system that's judging over them. And I really hope you don't take that seriously, because if you do take that seriously, you're legitimizing everyone's fears about the judicial board, not everyone's, but a large amount of people's fears about the judicial board and CCR in general just being bureaucratic tools used to punish people. But I don't know if you're actually taking that seriously, Chemo. I just wanted to mention that. Another thing is reasons for McNally not being very cooperative when this case was first, brought to everyone's attention. Well, I mean, you had a chair who used the credentials email, and I have screenshots to prove this, the credentials email to basically threaten Michaela, saying like, consider this your final warning, blah, 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 typical fashion of the chairwoman. So how could you ever trust a system that you've witnessed has purged people, you've witnessed has accepted chartering materials from somebody who wasn't the chair, despite them in previous judicial board rulings establishing, specifically Nick B. Steinwender, that the chair is in charge of credentialing materials. So you've witnessed all these inconsistencies, and you've witnessed all these like bureaucratic injustices, or what you believe are to be injustices. And like, how could you ever fault somebody for being hesitant for cooperating with that? And yes, she did come to the judicial board later, but that's probably honestly because like she actually felt that, that people were actually on board with her sentiments, that people also feared this system and that more people would support her. I mean, at the time, a lot of clubs were on board with what was happening. And the UCSD situation was the one that was the turning point. Another thing that I'll say is that she was listed as the plaintiff without consent. And as I mentioned in my opening statement, imagine the precedent. Just put yourself in her shoes for a second. Imagine if I went to UC Irvine College Republicans and I submitted new credentialing materials, but they weren't actually new. The only thing that was new was the executive board that listed my name as the president. And all of my friends were on the judicial board. And, you know, the president, the actual president of UC Irvine CRs, you're saying that like they would have no hesitation that they should just cooperate with that system when they've already seen the system like abused.
5 minutes remaining.
And then I do want to harp on the fact that Pano and Dylan saying that she didn't submit credentialing materials is false. Pano and Dylan saying that the credentials committee never voted to rescind Dylan's original materials is false. I'm looking at the minutes right here under Chairman Christian Chacon, where Pano actually moved to rescind the materials submitted by Dylan Martin. The floor was open to debate. Leslie called division. Christian called aye. Pano called aye. Leslie called aye. Harry called aye. Christopher Casillas called aye. And the chair called aye. So this isn't just like something I'm making up, Pano. Like you should actually keep accurate records of your minutes because you explicitly stated that one, that Michaela never submitted conflicting materials after the original situation, and two, that the credentials committee never actually rescinded that, which is false. It's just blatantly false. And just to conclude, I do want to mention that, and this vote, just for your record, Pano, was on June 11th, 2018. So if you can dig up records for that. I do just want to reiterate my initial point and my strongest point for this claim, this motion to dismiss our case, is that it could just equally, like I could copy and paste every single thing that Dylan Martin has said in that petition to dismiss my case and use it against him. Just think about that. There was already a chartered club at UCSD. There was already a president at UCSD. We knew who the president was because that club submitted those materials to us at convention, and Michaela McNally submitted updated materials upon her election. So if you dismiss my case based on this shoddy argument, I mean, you would just come full circle. You would have to dismiss Dylan's case as well. And I think I've established that pretty clearly. But I yield the rest of my time.
Thank you, Mr. Gates. At this time, the defense may cross-examine Mr. Gates. You're right.
All right. Wait, question here. Isn't this the point where we rebuttal, or is this just questioning him directly?
This is questions. You'll get rebuttals afterwards.
Okay. Well, how about at what specific point did I ever say that McNally never submitted materials? I never even stated that. When did I ever say that?
I can't remember the specific point, but I know that you have been, even if you didn't explicitly state that, you have been saying that McNally, after Dylan submitted his credentialing materials, she has never been a part of the organization and she has never made strides to be a part of the organization, when that's explicitly false. She submitted new credentialing materials, and so she wasn't just sitting there twiddling her thumbs and just accepting Dylan's chartership.
But surely you recognize that there's an inherent difference between saying that she never submitted materials and then saying that her materials are not officially recognized by CCR.
Sure.
That's important here.
But that's not what you said. My argument, no. Like all throughout your closing statement, your entire point was that she never put any effort into the organization because she believed the organization was invalid and immoral and corrupt and so on and so forth. It's blatantly false. Yes, she didn't pursue a case on judicial board for obvious reasons, as I've explained previously, but she did submit credentials materials that conflicted with Dylan's. So she did make an effort, and when she did that, under your chairmanship, she got an email from Ariana for some reason, even though she's not the chair of credentials committee, saying, you know, typical chairman things, saying that, like, you know, consider this your last warning, you've displayed unethical behavior, blah, 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 handling things that you should have been handling.
Now, didn't you say directly, and I remember hearing you say this just now in your statement, you said that in the minutes it says that the whole committee unanimously agreed to rescind the materials. Is that correct?
Yes, because they wanted
Yes.
to defer it to the judicial board, not
Yes,
because
so
they were some benevolent actor.
So therefore, that club hasn't correct me if I'm wrong, but wouldn't it be fair then to say that that club has not existed since the committee fully unanimously, under my motion, unanimously everybody agreed to rescind McNally's entire charter?
I mean, even if that were the case, which I don't think it is,
You
then
just said it was earlier. So didn't you just say that?
no, you're misunderstanding my argument, Bono. The argument is for the initial submission of his credentials materials being illegitimate. I don't care about the most recent one, aside from the fact that he also continued to steal members on his membership list.
But doesn't
That's the only area that we've
code care? Doesn't the CCR
2
credentials
minutes, 30
code
seconds
care
remaining.
about recent chartering status? Because I know you don't care, but doesn't the CCR chartering code care?
I just don't understand your question. It makes literally no sense, Pano. The whole argument that I'm making is that the credentials materials submitted by Dylan initially were illegitimate. They were accepted illegitimately because certain members of the board wanted to establish a coup club. So I don't see how your
so
point about
now you're bringing up a new point entirely. So hold on. So where's like your evidence, the foundation of your evidence for this like coup of many members collaborating within the credentials committee?
Well, my witnesses, did you not pay attention to my witnesses? I literally had, no, you obviously didn't, Pano. Just like you obviously didn't pay attention to the credentials minutes that showed that Michaela was making an active effort to get her club recognized, which you implied she didn't do. You implied that she wasn't actively participating and that she just rejected the legitimacy of the org entirely. So anyways, to clarify, when you like listen to my witnesses, you will hear that they've talked about how, let's see, that Ryana or Tiana, I forgot, mentioned how Dylan didn't just like benevolently say, hey, you want to talk about this? He also added that another board member,
1 minute
specifically the
remaining.
chair, was with him, and that they wanted to talk about it together. And then if you listen to Leslie, she also mentioned something to that effect, although I can't remember the specifics. So yeah, we've already mentioned that. Do I really think that it's like, yeah, so I mean, that's all I have to say on that.
Okay, so we are done with this portion of it all. I'm ready for rebuttal. Unless Dylan wants to say something, but I think we're good here. Yeah.
Mr. Dylan, do you have any questions before we continue?
No questions at this time.
All right, at this time, then the defense can make their closing statement.
All right. So let me kind of just clarify the main point here and kind of the whole point of the entire rebuttal that we just had between Representative Gates and I. I mean, the main issue here is he himself even admitted it with his minutes, is that I made the motion for the entire committee to rescind McNally's materials. I'm not neglecting that.
No. I said to rescind Dylan's materials.
Mr. Gates, please let him have his time.
We had plenty of time already. All right. Yes.
Well, you
so
did
I want
say
to
no.
Andrew, keep decorum. Keep decorum.
You said
everybody speaks when they have time to speak.
Yes.
Everybody speaks when they have time to speak.
This happened before.
Everybody speaks when they have time to
If somebody says something that's
speak.
blatantly false, you can interject to correct that.
And you can rebut it when you're rebuttal.
Vitale, one moment, I will correct him. Mr. Gates, do you have a formal objection?
Yes.
Please state it.
I never said that you rescinded McNally's materials. You're misunderstanding my argument. There was a motion, and I can send you the minutes to rescind Dylan's material.
If you have a problem with his argument, make that contention in your closing. An objection is something formal that's in the rules of evidence that you're complaining about, or an ethics claim, but it's not if he misunderstands your argument. If you believe Mr. Fusiaki's argument is poor, then
No, that's a factual claim because he said that I said that they rescinded McNally's.
And substantive factual claims can be made in your speech. Unless you believe Pon is perjuring himself, which would require us to move into something else, then we're going to move on. Do you believe Mr. Fusiakis is perjuring himself?
No.
Okay, so you can make that argument that he misunderstands you in your closing speech. So now we're going to allow Mr. Frusiakis to have his time. Kevin, where did we stop the time?
Sorry, my mic was muted. I stopped it at 4 minutes 33 seconds.
Was that at the initial interruption, or did
that
we?
that was immediately after Mr. Gates started speaking?
Okay.
So after the very first interruption.
Mr. Gates, if you have a formalized objection to something Pano is saying, whether that be you want to, you believe he's committing perjury, then you can make that. But if you believe he's just not understanding the argument or making a poor argument, you can make that in your closing statement. Let's respect everyone's time and maintain decorum. Mr. Frusiakis.
All right. So kind of what I was saying, and I think the passion on both sides really highlights the importance of this point. And that is that, like in the minutes and everything like that, the ultimate point here is that McNally's materials, in the end, did not stand the test of time. And regardless of whether or not people acted with different intentions, regardless of whether or not there was political collusion, which there wasn't, but even if there was, let's pretend if there was, legally speaking, that is irrelevant. It doesn't matter if the Russians influenced this. It doesn't matter if the Chinese did, because legally speaking, the end result is legally the same in that McNally's materials were ultimately not taken in priority over those of Dylan's materials. Now, the committee originally went, oh crap, we rescinded his materials. But at that point, it didn't mean that McNally's materials suddenly came back. It didn't suddenly reinstate McNally's materials. And that's the key point here. That's why this ultimately holds and why this motion should be taken. It is because that the entire school, UCSD, has been in limbo since June. And there's been no recognized chapter or charter from there since then. So this whole case, this past 3-4 hours, unfortunately, a lot, like 90% of it, even from both sides, was obsolete, because ultimately the bottom line is that there is no McNally Club. The only club that exists now is the new Dylan Club. Even the old Dylan Club doesn't exist anymore. The only club that exists is the one that was approved on December 6th, or whenever we had our last meeting. I'm pretty sure it was December 6th. So quite honestly, that's all that matters here. And I understand here the argument against it is really kind of this, like, it's becoming a semantical whole almost. It's becoming like, no, actually the other person's materials were deleted. It's like, okay, even if that happened, it still doesn't answer what I'm saying. I'm saying that McNally's materials ultimately didn't stand the test of time here, so it doesn't matter. So this whole case, it has to be dismissed. It has to be dismissed because it does not have any pertinence anymore. It's gone. It's done. It's decided. We officially ended this. It's over now, folks. Politically, it might keep going on, but it doesn't matter. Legally speaking, it's decided, and it was decided December 6th. It's over. So unless Dylan might want to add something here, but that's all I have to say. It's pretty clear cut.
Yeah, I have a couple of points to respond to in closing to Andrew's argument. So Andrew mentioned that it's not a good argument that Michaela hates / doesn't respect the judicial board. Ordinarily, maybe, but it is relevant, and I'll say why. So Michaela stating, we would accept, quote, we would accept no ruling, whether against or in our favor, from a body that serves to ensure an illegitimate leadership from consequences, end quote, is evidence that the plaintiffs will not rest until they get the result that they want. Essentially, they'll keep harassing us and interfering with the functioning of our property. So again, we believe that the current action by the plaintiffs constitutes a nuisance, which can be grounds for dismissal with prejudice. And again, according to common law principles that I already mentioned, in Crosstext Northern Pipeline LP v. Gardner, quote, taking this opportunity to clarify the law, we hold that the term nuisance refers not to a defendant's conduct or legal claim or cause of action, but to a type of legal injury involving interference with the use and enjoyment of real property, end quote. So the petition that sparked this whole thing, the case's subsequent dismissal by the plaintiffs without
1 minute remaining.
The current petition brought forth only after a new club has been chartered, after a 6-month period of time in which no action was taken by the plaintiffs. It's a continued annoyance and interference with the use and enjoyment of our property. So this represents like a real, situation that we need to look at. And Michaela's message there, I mean, it's showing that this side is not going to stop badgering us until they get what they want. And at the end of the day, our materials are legitimate. So, I mean, if we don't we don't dismiss this, and we're going to keep hearing the issue, brought forth again and again if it's not dismissed, especially with prejudice, because I assume they would keep attacking and attacking, because that is what Michaela herself has made clear that she would do. Allegedly, I don't want to exactly put words in her mouth, but Representative Gates also alleged that charters were revoked. However, our arguments have stated this clearly in the beginning, that quote from our opening statement, no charters were revoked.
Time has expired.
Sorry.
Thank you, Mr. Martin. So I have a couple ending questions now that wait, I apologize. We actually have our final closing statement coming from the plaintiff. So Mr. Gates, you have 5 minutes for your rebuttal.
Oh, you're muted.
Just to clarify what I was trying to argue, Bono, because I do agree that there was some semantic confusion there, is that, okay, so let's say that you are right in your recent rebuttal, and that at the time of Dylan's submission in November, I believe it was November, right? The recent one? Could you correct me if I'm wrong? It was November, right?
November 27th.
Thank you. November 27th. Pano, you just said that at the time of November 7th, there was no existing club at UCSD. If that's the case, then why did McNally email you guys on October 10th, and I have the email to prove it, with her credentials materials, with the message, and I quote, in case you missed the first one, and then Ariana Rowlands, the chair, instead of you, for whatever reason, the chair of the credentials committee, said, consider this your warning. You must take this to J board because there's already an existing one, is what she was implying. So what you're saying contradicts what Ariana said, and not only what Ariana explicitly said, but what the credentials committee has been upholding. So if that's true, if you're saying that my argument from the beginning has been that the initial submission was illegitimate and illegal of Dylan's materials, so his club should not be recognized. But then you're going around and arguing, in the last 10 minutes, that there was no club at the time of Dylan submitting materials. That's not the case. Or even if it is technically the case, it's not how you guys have been enforcing it, and it's not what you've been telling Michaela McNally, because she was explicitly told to go to the judicial board, implying that there is an existing chapter. There is some confusion. So that's what I was trying to convey, and that's what I'm not really understanding your argument. But anyways, just to reiterate, Dylan's original petition to dismiss this case could equally be used in retrospect to nullify his original submission. And while Pano might say that his original submission was nullified and the material submitted November 27th established a new club, it's just not how the credentials committee has been enforcing it. So I don't know. That's my closing statement.
Thank you, Mr. Gates. At this time, the judicial board can ask any questions. First, Mr. Vitelli, do you have any final questions for either party?
No, I don't.
All right, I have a couple. So I would just say, first off, this is a question for both. I'll hear it first from Mr. Frusiakis and Mr. Martin, second from Mr. Gates. What do you believe the extent of the credentials committee in determining merit is? Because the credentials code is pretty clear on some sort of metric, but clearly there seems to be a contention of subjectivity. Where do you believe the subjectivity begins? And once that subjectivity begins, what is the necessary threshold of merit that needs to be met?
All right, so I'll answer this because I'm the chairman of the committee, so I might as well answer this. In terms of merit, I think that's a pretty good question. I really have, as head of the committee, really since I've taken over, I've really relegated merit to the judicial board. So I've allowed the judicial board to decide on merit. From our end, we only decide on really the materials. So what is submitted to us, then we will decide that and we will discuss it. The reason why there was that original motion to refer it to the judicial board is really for that reason. I'm understanding, so I guess the idea that there was this confusion that had to come out of the judicial board, I mean, that really has to be clarified from going back into the judicial board's records and reading about that and looking into that. That's not really something I can really speak into in huge detail. and the perception of how the court was received at that time, I can't really answer that either. But quite honestly, it's like there was never a time where we as the credentials committee approved and then went, okay, we're going to now reapprove McNally, because what happened was is we viewed it like a third rail. Like, we didn't want to have a political battle over the merit of it. So that's why we referred it to the judicial board, because we said, we don't want to deal with this. We don't want to touch this. This is a judicial board thing. And that's ultimately why, and it even says in our credentials code that it should be referred to the judicial board if it's a discussion of merit. And we also had to wait on the details to come out as well. So there was never a time where we said, especially not in November, where I was suddenly like, okay, folks, we're going to reapprove McNally now. Like, no, that never happened. There has, like, I remember her trying to submit stuff again randomly, but it was never accepted and never discussed upon. And well, it was discussed upon, but it was never approved by the committee and never actually taken in, because the reason is because she ultimately dismissed her original case, and it was a big mess and it didn't make any sense. And so the rest is history. So at this point, it's just being circular. But to TLDR, Chemo, to answer your question, I think that, quite honestly, that the judicial board handles more with merit. The credentials committee is about meeting the 4 criteria. And that's why this whole case, I've been harping that, and the witnesses I brought, Chris Casillas, Ryan Pavey, I kept asking that question, because that's ultimately my philosophy as chairman of the credentials committee. Is, does it meet the 4 criterion? If it does, good. But if the judicial board says someone's suspended or they can't submit materials, then I'm not going to touch it. That's the bottom line. So that, unless Dylan wants to add something to that, that's going to be it for me for that question.
Thank you, Mr. Sarkis. Dylan, do you have anything you want to add to that?
No, I don't think so.
Mr. Gates. Mr. Gates.
Oh,
yeah, you're muted, Andrew.
One moment while I just organize my notes.
No problem.
All right, so my rebuttal would, focus on what Panos said. So I do believe that credentials does investigate merit. And I think this is evidenced by the fact that at CCR, historically, and in, the current constitution, one of credentials committee's jobs is to specifically call every single member on a submitted membership list when they're determining delegates. This isn't a duty that is handled by the judicial board. It's a duty handled by the credentials committee. So when I hear that the credentials committee just blindly accepts whatever is submitted to them, and they defer to the judicial board whenever there's a question of whether those materials are legitimate, I mean, it's just blatantly false. You do recognize whether materials are legitimate in everything you do. If I were to say, hey, Pano, I just started a club at UC San Diego, you're saying that you would defer, and I submit a UCSB school letter of recognition. Well, just discerning that it's UCSB and not UC San Diego, and this is the most basic, rudimentary example of establishing merit or legitimacy, that alone is you're discerning merit. And with your knowledge of me, I'm sure you wouldn't accept that from me. You know that I'm not a UC San Diego student. You'd be like, no, this Andrew guy, he said that he's from UCSB. Like he was the president of the UCSBCR. It's like, when did you start attending UC San Diego? So I don't see how that can't be applied to literally every other thing that you submit as part of the credentials process. When Leslie mentions in the credentials committee meetings that, hey, look, there are members on this list that conflict with an existing chapter at UC San Diego, maybe not a chartered chapter, but an existing club, so they were stolen in some way. That's a question of merit, and I think that's a question that credentials can address, and there's precedent for that. You're constantly determining legitimacy of materials, especially at convention. You know, I can't just submit. I mean, that's part of the reason why St. Mary's wasn't given votes. They didn't meet the requirements. They didn't submit, what was it? I think it's 20 or 30 full names with numbers and emails. So I just don't buy the argument that judicial board is the one that discerns merit. And I also want to just reiterate that Ariana said explicitly, you know, this is your final warning about your past and current unethical behavior. I will be investigating it, not the judicial board. She will be investigating it as part of the credentials committee. If your UCSD chapter wishes to be chartered, you must file with J-Board. So just to reiterate on an earlier point, if it is indeed the case that there was no existing club, one, why didn't you vote on McNally's submitted materials in October 10th? Because at the time, according to Pano, there was no existing club. Two, why did you defer it to the judicial board? Why did Ariana explicitly tell Michaela to go to the judicial board? That's my closing statement.
So, Andrew, I just want to follow up quickly on that, just so I can clarify the argumentation. What is the extent of jurisdiction do you believe the credentials has when determining merit? I.e., like, at what level do you believe that merit interpretation becomes illegal? I don't want to even use that term, but not justifiable, and thus subject to judicial board review. My question is, to what extent does a credentials vote constitute a factual state, right? Because we both agree, like in the instance of St. Mary's, that some sort of factual state began to exist once the credentials made clear a certain factual state existed. And even if people disputed that factual state was accepted. At what extent would the factual state become unclear or illegal and thus subject to judicial board review?
So, okay, so you mentioned how in the case of St. Mary's, it was a factual state. Correct me if I'm wrong, but you're referring to the fact that it is a fact that 30, I believe it's 30, let's just say that it's 30, 30 names need to be submitted to get delegates at convention.
I don't mean that, sorry. So let me clarify, this is semantical. What I mean by fact is a question of fact versus a question of law. So clearly the credentials committee has some extent to interpret the facts in the world because, as you said, they have some sort of metric they have to meet. Pano said the same thing. My question more so was, what extent of the world should they interpret facts? And more so, at what point does their factual interpretation become subject to judicial board review? So to what extent do you have to say, oh, the credentials committee, even if I disagree with them on merit, this has no merit? Do you think merit is just kind of determined in context the situation at hand? Is there some sort of scaling? Just because from a judicial perspective, it's very difficult for us. We prefer not to make rulings directly on just interpretations of fact, because then that requires we go down the testimony. It's more of designing a metric scale. That's how most common law is formed. So the first step to determining fact would be, okay, to what extent do I need to determine that the credentials committee cannot rule on something? So I think more so the question to you is, at what extent does a credentials ruling, which we can both, I think you agree with Pon that he made a ruling on the existence of a club, which right now is Dylan's club. At what point is that existence or that ruling not legal?
Well, so if you're asking for my personal beliefs, I don't believe in the judicial board, and the fact that this ambiguity is created, because I do agree that there is an ambiguity, is the reason why everything should just be reserved to credentials. Because in the past, they judged, and even currently, like, in the past convention when the judicial board already exists, there wasn't this blurry line. The credentials committee was in charge of verifying not only that people submitted materials, which is a question of fact, like I submitted a constitution in my email to credentials, that is a factual thing, right? They also were in charge of verifying whether that constitution was legitimate. And obviously, that's why they required.
So I understand your procedural concerns.
Well, one second. That's why they required a signed document from like an Office of Student Life person or like a letterhead from the school, because they weren't just concerned with the fact of you submitting a constitution. They were concerned with discerning the merit of that constitution. And I believe that still holds when we look at convention chartering. and I think that it should hold. Like, I don't think that judicial board, even if it does exist, I don't think that it should exist. If you could convince me it should exist, I don't think it should be involved in credentialing. I think the credentials committee should be able to vote on this, and every other, executive board decision should be a majority vote by the executive board. It shouldn't really go to the judicial board. But the problem I have is that the credentials committee illegitimately voted, they didn't have proper materials. They didn't discern the merit of the materials submitted by Dylan, and as a result, we had him submitting just a false executive board list and constitutions that didn't belong to him.
So, okay, I think that gets more to the question at hand I have. So do you believe, for the credentialing materials at hand, do you believe that he didn't submit one in the requirement, or just that they were illegitimate that were submitted and thus should be rejected?
Well, he submitted the requirements in the sense that and this is where you get to the distinction between factual and merit, is that he submitted the requirements in the sense that he submitted a constitution, a membership list, a list of executive board members.
I get what you're saying now. Okay.
But the problem is that the merits of those, or the legitimacy of them, were just completely wrong, and the credentials committee failed to review that properly. Does that make sense?
Yes. Okay, that clarifies a lot. So just going back to the prior, I would just say this is more of the plaintiff's opinion then. What should be the extent of merit that judicial board involves itself in? Because what you're asking us to do as justices is to extend the power of the judicial board to decide merit for the credentials committee. What metric does the plaintiff ask we use? And I would ask the defense kind of already made their claim clear that the judicial board should have the ultimate metric for determining merit. What is the metric of merit that the plaintiff asks us to have in this case?
A bit confused by the question, but I think that the merit...
Sorry, allow me to rephrase that.
Yeah, go ahead.
So what I'm asking is, for instance, the defense said that we should be the ones to ultimately decide merit, which is we can honestly just say is kind of an arbitrary factual distinction, right? We're trying to empirically prove something is true or not. And the judicial board would just have 100% control over that. The question to you more so is, what extent should the credentials committee have? Because you seem to believe that the credentials committee at one point should be interpreting merit and that a majority vote from them determines that merit, but you're also asking this judicial board determine merit.
Right. Okay, so I get what you're saying. So I would respond that this is kind of bordering on a question of that it's very hard to answer. It's resemblant of asking somebody, this is an example.
It's a jurisprudence question.
Right. Asking an ANCAP who goes to court to sue somebody, and you ask them, you don't really believe, on one hand, in your ideology and your professed statements of belief, you've said that you don't believe in an actual government. And on the other hand, you're coming to the government. Or it's in another analogy would be asking someone who doesn't believe in roads or whatever, libertarian point, and asking them okay, well, why are you using roads? And so I think the proper answer to that would be that we've established a system such that the judicial board is able to judge merit, right, as evidenced by the fact that we're even having this case. Right. I think in an ideal system, the credentials committee would judge that. But I also think that there's so many other institutions within CCR that would be different if we didn't have a judicial board that wouldn't allow for that abuse from the credentials committee. And I think that there's some misinterpretations that we have with committees that kind of contradict what the Constitution has previously held. For instance, executive board members.
I understand your the political contention. I think more so the question I'm asking is, based on the current law, which is what judicial board has to rule on, what is the extent of our jurisprudence? Because clearly we're basically moving on traditionally executive authority, which is credentialing. So, and it is kind of, to some extent, a question of merit. I'll just say that. Because it's asking, for instance, just determining if a phone picks up is a question of merit. Now, it's minor merit, and it's highly codified merit, but it's still there. I think my question is, to what extent should we be judging merit questions? Or how do you believe the merit question is best weighed here? So I'm kind of asking you for a framework on how I should be weighing facts here.
Okay, so the framework is that, how do I formulate this into like a specific code? I think that's a little hard to do on the spot, but I think that merit is self-evident. It's very obvious. Like I said earlier, if you knew that I was a UCSB student and I submitted to you a UC Irvine club letter, right? You would question, and you wouldn't just ignore that just because nobody has submitted it in their pile of evidence that I'm a UCSB student. You would know that I'm a UCSB student, so you would immediately reject that. I think the line between merit and like fact, I think it's just like, I think we're not aptly defining it in this discussion, so it's just very hard for me to answer that. I think that they're like intrinsically connected. For instance, it is you can simplify factual statements to be like, Dylan submitted a constitution, but the question of merit is also, that I want to address, is also a question of fact. Did Dylan submit a constitution for a UCSD college Republican club that was legitimately elected by its constituents? And the answer to that factual statement is also an answer to the merits of his credentials materials. So I don't really see the distinction clearly. I think that, that's basically the best I can explain it.
So do you then see a credentials vote as not a legitimate sign of kind of a consensus on merit if you're correct that the merit is self-evidently wrong in your case?
Are you asking, do I think that the decisions made by the credentials committee?
Yeah, so basically I'm saying, to what extent do you believe the credentials committee can be flawed? What do we need to portray to the court to show the credentials committee is flawed? What's like the elements, so to say?
Well, I'm not really interested in displaying that the credentials committee is flawed, but their means of...
Or their means of determining a fact.
Well, that's more of a like general policy question. My submission is that they've misinterpreted, that they've misjudged the credentials material submitted by Dylan.
Okay, so it's
sense?
more of a contextual framework then, kind of piece by piece.
Well, yeah, obviously, because they haven't really established any code. As Pano was saying earlier, what they discussed about in their meeting was that they don't really have a code for addressing these sort of things, any formal one at least. But I think that like previous precedent has established that it is their job to discern whether a constitution is like a legitimate constitution, whether a school of recognition is a legitimate school of recognition. And I think they've just failed on that front.
All right, perfect. That's actually all the questions I have. One moment, look, most of this got answered at some point. Oh yes, I had a couple. So this is for both parties. On the practical absurdity question, so I understand that. In fact, I think I actually noted a practical absurdity problem in the original McNally case. I think the question was, if there was truly this injustice which formed. So I understand McNally's specific reason, but doesn't it seem that there wouldn't be an absurdity actually formed if there was a time frame that you could still petition? Because it seemed in this case that McNally didn't petition within the 6 months. And that's more so the reason why a new club got chartered, right? There seems to be some sort of compelling government interest to expand CCR. I think the Judicial Board kind of postulates that. I would be interested to see an argument that expanding chapters is not a compelling interest to the organization. I think it's pretty clear it is. But the question would be, would we not then expect somebody to come forward? Because the specific ruling in McNally was a very technical due process one, I will say. Perhaps that was not best for the factual situation at hand, but it was one nonetheless. So the more so question at hand is, doesn't kind of just seem natural for the state to expand into new chartered territory in lieu of somebody submitting new credentialing materials. Because if it was just a malicious act, in theory, the McNally case could have been resolved. So I think the TLDR of that is, how's there practical absurdity if they clearly could have petitioned within a lengthy period of time for the case, as was asked? Either party can answer first.
Sorry, my mic is muted again. I think I've already established multiple times, and it's getting kind of a little bit redundant, that there were a lot of reasons for why McNally didn't actually follow through with the original judicial board trial. I mean, namely that she was filed as a plaintiff and she never even filed a petition, so that kind of creeped her out a little bit. And also the fact that she viewed the judicial board as a biased institution. But I mean, also I think that, like, sorry, where was I going with that? Yeah, there were. I don't really see it as relevant that she didn't follow up with it. And I don't think that there is a statute of limitations established in the
there's
Constitution.
definitely not.
Right. So it's just like, if there's no formal statute of limitations, I get like your why you're asking, but I just don't think that it's like going to add to this trial, because there's no formal statute of limitations, so it's
Right.
relevant, you know?
No, I think I was referring to the general common law principle that if there cannot be an absurdity within the law, and if there is, it needs to be struck down immediately. So I think I was making the differentiation between a poor law and an absurd law.
So what are you asking me? If it's absurd that we don't have a statute of limitations?
No, no. I was asking, do you believe this case is an absurdity, or in the plaintiff's opinion, would it just be what you consider to be a poor law? Because an absurdity means a physical impossibility occurred which prevented the plaintiff, in this case McNally, from petitioning. A poor law would be she was unable to fully give out her merit or something along those lines. But an impossibility, which is an absurdity, is different. So from a legal standpoint, I don't want to get caught up in the jargon too much. It's just like, when I hear the term practical absurdity, I'm thinking, okay, that's the first thing I need to address in my written opinion, because clearly if there's an impossibility, that needs to be addressed. Do you still believe there's an impossibility, or do you believe it's just kind of what you would contextually believe to be a tragedy?
So I don't think that it was impossible for McNally to, like, participate in the judicial board trial, if that's what you're asking. I mean, it obviously was not
or even
physically
like
impossible.
an impossibility to petition the credentials board in an equitable way.
In an equitable way, I think so, but
And by
again,
equitable, I mean procedural, not merit-wise, an opinion of merit. Because in determining an impossibility, we're determining a question of merit, or sorry, opposite way. In determining impossibility, we're determining a question of procedural, not merit. So that's why I was asking that question. So that I think clarifies to me one of the more technical points I wanted to address in this case, because I don't want to have to write a lengthy opinion on that. But that clarified. I think the plaintiff clarified his opinion on that. I don't need to hear from.
I guess I just like. I mean, I wasn't prepared for these. Like, just to be frank, I wasn't prepared for these like more general questions about procedural, like legitimacy and all that stuff. So I'm sorry if I can't give an adequate response. If you want to send me like a written thing that we can discuss, then I'd be happy to do that. But I don't know if like my opinion on that should affect the ruling, when you obviously said that you're going to address that based on your own like deduction and stuff.
Right, and I will say, so just kind of at the end of this, in my final opinion, I try to have narrow rulings. I think this is honestly just a massive tangent on jurisprudence, but sometimes the judicial board needs to consider a framework of how to decide future cases, which is kind of the job of the judiciary. But I think I will actually end up sending something, mostly just for my informational perspective, so it's kind of just a follow-up that I can cite later. At this time, Mr. Vitale, do you have any final questions?
No, I don't.
Okay, actually, I think that answered all my questions. I would like to thank everyone so much for coming out to this. It was a lengthy 4-hour period. So in the technical realm of things, I have 1 week to publish my full opinion. That's going to go very fast. I hope to publish it before retreat next week. So I leave late next Friday for retreat. I hope to have it probably Thursday night then. It's going to be lengthy, but I hope it will address all of your concerns.
January 4th, you mean? Or January 3rd, my bad?
Yes, I believe. Is that the next week, Thursday?
It's Thursday, yeah.
Yes, so I will probably at 7 p.m. be having, as we did similar with Mr. Vitelli's case, a full disclosure of the case. And I will be reading, it depends how long the case is. If the case is like 70 pages, I'm not going to read 70-page novel to everybody. But I'll give a shortened summary of everything, and I will answer questions from the parties. I'm not.
Can you read the 70-page novel in front of a fireside chat, Chemo, or in front of a fireplace?
No.
Okay.
Unfortunately, not. I'm not paid for that. So, thank you everyone for coming out. At this time, I'm going to adjourn because we've gone through all the procedures. Everybody have a good night, and you will hear back from me then.
All right. Well, you have a great day.
Have a good night,
everyone.